Page mentioning supplementary list submission. Page number 1, serial number 127.
Your Lordship, item number 5, the girl has been rescued, Your Lordship.
Item number
5, Your Lordship.
Pencil data dala. Pencil data diya.
That's it. Item number 2.
Pencil or rubber is all.
What is your good name? Blood Council?
Your Lordship, Afraz Suhail, Your Lordship.
Mr. Afraz Suhail. You are not there. You are on
Your
instruction.
Lordship, I have filed my wakalatnama, Your Lordship.
Afraz Suhail. Yes. Blood Council appearing for the petitioner has submitted that the victim has been rescued by the police, and as such, this petition has become infractious. So, accordingly, this petition is dismissed as infractious. Okay, Mr. Suhail.
Deeply obliged, Your Lordship.
That's it. Item number 2.
Yes.
That's it. That's it. Item number 2 may be adjourned to last week of August.
PL.
All right, I will see and pass the order. All right.
Deeply.
All right.
Page 2, item 8 to 12.
My lord, item 7.
Permitted to withdraw.
Item 11.
11 months.
My lord, item 17 may kindly be.
Mr. Sethi, GS Sethi Blood Council has stated that he has instructions to withdraw this appeal. So a memo of appeal has been filed. In this regard, we do not find any impediment. This appeal stands dismissed as withdrawn. So already there is an application there.
Page 3, item 13 to 19.
My lord, item number 17. So lordship may kindly take up the matter.
Yes, today itself,
Your lordship may kindly be taken.
we'll just mention it 12.
Gratefully.
Make it is call it on 12. Huh? Okay. Next.
Page 4, item 20 and 21.
Item number 20, my lord. Item number 20. I'm appearing to the Central Pollution Control Board.
Yes.
On the last occasion, this Honorable Court had directed, on the basis of the state government report, the Central Pollution Control Board to file a reply, my lord. What's my granting time will file the reply, my lord. I'm appearing to the Central Pollution Control Board, my lord.
You're appealing for the Central Pollution.
Yes, yes, ma'am. It's a so moto PIL, my lord.
It is for you are for the opposite party number 7.
Yes, yes.
No, you are for the
Yes, yes, Central Pollution Board.
Yes. And 13 also, I think so it is the Groundwater Commission. At the request of Mr. BP Tripathi and Council appearing for the Central Pollution Control Board, the opposite party number 3, let the matter be listed on 13th of September 2023.
Deeply grateful, deeply grateful.
In the meanwhile, the counter affidavit shall invariably be filed. Anyone appears for the so Mr. D.K. Mohanty, learned additional government advocate, appears for the opposite party's number 1, 2, 3, 4, 5, 1, 2, 3, 4, and 5. All right. In this case, who is representing the registered judicial?
By the government,
Government advocate?
Government.
Mr. Behra,
no, Mr.
who is
No,
appearing
Mr.
for this item number 20? Because I think nobody is
I am
taking care.
appearing for the
Your specific parties in the opposite parties
Yes.
that we have mentioned, but I think someone should appear for the registered judicial. Mr. Mudoli, you appear for the registered judicial. Mr. P.K. Mudoli, Lamentation Government Advocate, is requested by this court to represent the registered judicial Orissa High Court. As was instance, this public interest litigation has been taken up. It will come on this 13th of September. Yes,
Page 9, item 22 and 23. Page 10, item 24 to 29. Page 11, item 30 to 33.
item 32, my lord, I pray this matter may be taken up.
just a minute. Item number?
32, my lord. I pray this matter to be taken up.
Yes. Yes, Mr. Kanungu.
Yes, ma'am. This matter to be taken up, I pray, ma'am.
All right, we'll take up. Just be there at 12. Let us see. Oh, that's 12. Come at 12.
Page 12, item 34 to 37. Page number 13, item 38 to 41.
My lords, I may be pardoned to mention item 41, my lords. I'm through VC, my lords. Sadly, I'm unable to appear today. My lords, item 41. Actually, my lords, there's a matter where the LTPC, my lords, the petitioners have filed this public interest litigation, and notwithstanding there being no interim order, my lords, they're creating a ruckus in the district administration that the work has to stop. Now, this is a project of national importance, my lords. State government has given us all clearances to go ahead, and the statutory authorities have given us all clearances.
What do you want this matter to be taken
My,
up?
my lords, on Monday, my lords, I pray that it be taken up on Monday. Positively, my lords.
All right, Monday.
I'll mention it again, my lords, on Monday. Your lordships may kindly take it up on Monday.
No, not Monday, just. Mr. Milan Kanungu, let us know advocate stated by Mr. A.N. Das and counsel for the petitioner. Let
For the
matter
OP
be-
number 3 and 4. We are for the OP number 3 and
Open number 3 and 4. Opposite party number 3 and 4. Who is appearing? for
I am
petitioner?
appearing for this state, OP1.
All right. The matter will be listed on Monday. Monday is 14.
14.
14, August 2023. You are for 3 and 4.
Yes, my lords.
He is for
You are for 1 and 2.
1 and
Mr. G.K. Mohanty London, President Government Advocate for 1 and 2.
Obliged, deeply obliged.
Page 14, item 42 to 47. Page 15, item 48 to 51.
I beg pardon, I filed a petition for appropriate orders which was disposed of in the month of March. My lord,
Just a little closer to the microphone. You are not audible. Or be a
Sorry.
little louder.
I
Yes.
filed a petition for appropriate orders for grant of guardianship certificate.
What kind of appropriate order you
For-
require from this court?
My lord has disposed of a Mata case wherein a guardianship certificate has to be granted. Unless the guardianship certificate is not granted, I cannot move it.
Ah,
That guardianship is not being given by the registry. They said that
all right. Take it, huh? Take it. It will come on 16th of August.
my lord,
Pardon to mention, my lord, when a writ appeal,
Also, the place the file before me, huh? Why the matter is not listed? up to filing.
But a writ appeal has been delisted, though it was listed on the last two weeks back, well, but could not be taken up due to amount of time.
But we are giving the date for all the delisted matter could not be taken up. Have you checked?
Checked on the website about the next date.
But next date has not been fixed. It has
so-
been in the list section.
So
It
how
has
will
not
you
been
say
fixed.
Check up.
delisted?
There should be a date. You just check up the High Court CIS. You'll find the date. All right. If you find difficulty, come any other day. We'll accommodate you. All right.
Pardon to make mention, my lord.
To mention, my lord. This case
yes.
was directed to be listed on 21st April 2023. But it has not yet been listed. The accused, the convict is inside the bar for more than 10 years. It is a life only. So the case may kindly be listed. Criminal appeal number 391 by 2014.
This is a specific assignment in this about these cases. Have you mentioned before those case?
My lord, I had already mentioned.
All right. Give the list. We'll check up and then we'll pass the direction. Take all the mentions. You
May
can
be
just
pardoned, my lord.
ask the registry to scrutinize and report back at 1:30. Yes.
Pardon to
of
make
matter.
mention, sorry.
May be pardoned, disposed of matter by Honorable Chief Justice and by Mr. Justice M.S. Raman. Modification. Your Lordship is sitting today. May I pray to list this matter?
You mentioned before that bench at 3:45. There's a division bench of the
My-
Chief Justice M.S. Raman. Okay.
I was of the opinion that your Lordship will.
Oh,
Anyway.
your opinion is very valuable, but you have to go for the better functionality.
My lord, my.
Yes.
I beg pardon, my lord.
Just wait, madam. What is your
Pardon for make mention, my lord. One review petition 205 of 2021, my lord. This is a pensionary benefit. My lord, may kindly take up this matter for fresh admission, my lord. From 2021 till yet, this is not.
give the just this.
The number, madam?
205 of 2021.
No, what is the nomenclature?
A review petition. REWEPT.
Review of what? Writ appeal?
Read appeal.
Just speak up.
I beg pardon, my lord.
Criminal appeal of 2015, my lord. It is coming within your lordship assignment, my lord, for bail.
Don't give date or check up the status and then give the date.
I beg pardon, my lord.
Yes.
One matter, my lord, the PIL. It was disposed of during vacation, my lord, by Honorable Justice R.K. Patnaik, sitting with Honorable Justice S.K. Mishra, my lord.
Yes.
My lord, I have filed an application for extension of time. They are not, the Honorable judges are not sitting division, my lord. So can it be taken?
All right, it's a vacation bench. It will come to the assignments. Now give the list.
My lord, it may be taken up on 14th, my lord. Because tomorrow is the last date, my lord. Tomorrow is the last date, so your lordship may kindly take up this matter on 14th, my lord. 14th.
All right.
And another matter, my lord, in a writ application 12098 of 2023, my lord. It was listed on 21/4/2023, but in a bench which was not assigned with the matter, my lord. My lord, the honorable bench, my lord, they said, my lord, to list it in appropriate bench, taking permission of the honorable Chief Justice, my lord. From that day,
this just to go and mention before the registered judicial take, the court has
I
asked.
have been mentioning on 4-5 occasions I have mentioned, but
Go today.
oh, bless me.
Go today because he will come in his difficulty. You mentioned that I asked you to go before him. All right.
I may pardon, my lord. I may pardon one matter, fresh writ appeal. Filed by state, your lordship may pick any date next week.
It will come on 16th of August.
Any date.
Just put a date on 16th of August.
Pardon to mention, my lord. My lord, it's a review petition arising out of a matrimonial appeal. It was before your lordships and Justice M.S. Sahu's bench. It was specifically adjourned to 7/7/23, but it was not listed. Lordships may take up this matter.
You go to the registered judicial and he will bring this matter. I will constitute the bench and then the matter will be taken. At present, this bench is not available. So you go and mention the matter before the registered judicial and give the reference that what I have told you. Right?
Highly obliged.
Registered judicial, not to the deputy registered judicial.
Subject to your lordship's kind leave, my lord.
Yes.
Your Lordships, item number 8 of today Lordships list. My lord, on the last occasion, there were 2 defects which was raised by the registry. I have been cleared.
Mr. Counsel, you just wait when the matter will be called out because you have completed the mention. Now you wait for your turn.
I am sorry, my lord. I am deeply obliged, my lord. Thank you.
Yes.
Supplementary list, fresh admission, item number 1.
Item number 1, my lord, last occasion, your lordship directed to remove the defect, but there is only one defect. Your lordship kindly ignore that. There is some defect relating to margin that may kindly be ignored. My lord, this is a matter. The prayer of the writ petitioner is that my application for issuance of occupancy certificate. My lord, the fact of this case is that the petitioner is a promoter, and the construction has been made in a rural area, and construction has been started in the year 2011. By that time, there is as this is a related construction has been made in a rural area, no occupancy certificate or restriction were not required by that time. Thereafter, in the year 2016, RERA Act came into force. My lord, your lordship kindly, Annexure 1 is the approval of the BDO. By that time, as this is related, constructed in the project has been started in a rural area. Therefore, BDO PPL has approved the project. Thereafter, under Annexure 3 at page 30, my lord.
This real estate properties.
Page 30, Annexure 3, my lord. This is the notification issued by the government, which is under which I made application to the government for to regularize the project, my lord. Paragraph 3 at page 30, Annexure 3, my lord. Odisha Real Estate Regulatory Authority, ORERA, through their notification dated such and such, has made it obligatory for developer to get the real estate project registered under the ORERA, irrespective of location of the project. Consequent upon the publication of such notification by ORERA, a large number of real estate projects which were taken up in rural area. I am coming within rural area, based on the approval of the BDO, have applied for registration with ORERA. Since the approval of the BDO and PRIs were accorded prior issuance of the guideline by the PR and DW department, ORERA is not able to grant registration to this project. While submitting a set of suggestive guidelines, validate this plan, ORERA has requested the government for issuing order to process the pending application pertaining to the project approved by the BDO PRIs prior to the publication of notification, madam. Thereafter, next para, the Real Estate Regulation Development Act such and such make it mandatory to register all the ongoing and proposed real estate project to be registered with ORERA. Since it is a complex issue and involve safety of a large number of home buyers, the matter was under active consideration of the government. After careful consideration, the government have now decided that the following procedures shall be followed to streamline registration of such project. My lord, thereafter, under Annexure 3, this is the form number 1, where regularization of existing building. My lord, out of 1108 flats, we have already transferred near about 800 flats to the purchaser, my lord. Thereafter, I made, as per form number 1 at Annexure 4, page 45, my lord. The present petitioner made application to the DUDA, the project director of District Urban Development Agency. This form number 1 is annexed to the notification, my lord. And that is, your lordship, from the top, your lordship will find that the same has been received on 31st November 2020. But till date, no decision has been taken.
All right.
My lords. My lords, the prayer may kindly be seen in the writ petition. Basically, the petitioner is praying that the occupancy certificate may be issued to him so that he will be eligible to sell the flats, etc., etc. And the so-called occupancy certificate is a mandatory requirement for registration of the sale deed. There is no dispute in it. So occupancy certificate is to be granted by the ORERA. He has applied for occupancy certificate as has been awarded by him, and that is pending. So it is a case where ORERA is to satisfy the petitioner and give relief whatever he wants. And he has included all government parties, all the.
We are not issuing notice on the government parties.
Only ORERA may be issued to.
Yes.
Only ORERA opposite party number.
4 perhaps. Mr. D. Nanda.
Opposite party number 6.
6 and
Mr.
3,
D.
my
Nanda.
lord.
6, no?
You are Mr. Nanda, I think.
No,
D.
no.
Nanda.
My lord.
Appears for the petitioner. A promoter dealing with real estates. According to the petitioner, he had an in-conflict project within the village, but the project started with due permission from the Block Development Authority. After the real estate within bracket regulation and development, close the bracket Act 2016, comma, RERA short, has come into effect. The petitioner has applied to the said authority, the real estate the authority, for registration of the project as per the provisions of this said Act. The said application for permission for development of the building and subdivision of land was made on 3/11/2020.
My lord.
3/11, no, sorry, no, 17/12. 3/11 or 17, just give the date of your application. Where is your application?
My lord, that is Annexure 4.
The Annexure 4 is a.
That is received on 13/11/2020.
13/11?
2020.
13/11/2020.
ORERA application no?
Stop.
To the project director.
But till now, no action has been taken by the real estate regulation and development authority on the said aspect of the matter. As a result, the petitioner and the person who had agreement to sell the flats are facing serious difficulty. Stop. Basically, the prayer of the petitioner is relating to the issue of occupancy certificate. So the individual flats can be registered under law. Stop. Be that as it may, issue notice restricted to opposite party number 6 at present. Notice is made returnable on 12th of September 2023. Steps for service of notice on the said opposite party be taken by the petitioner within 3 working days from today.
Item number 2.
Main titular.
Yes.
I just think the adjournment of the matter last week of August.
Yes. Mr. Mohanty.
No, my lord, it is I think they have not sought copy. Union of India is a party, I think. They have not sought copy on us.
The petition has not served copy.
No. And as it appears from the list
Mr.
of
Roth, what happened? You have not served copies?
Union of India as it.
And have you removed the defects also?
Is it item number 2, my lord? Yes, sir.
But in the list, it is noted that Akshay Kumar Naik versus Union of India.
We don't have a copy also. We have not received the copy. No, we have supplied copy to Union of India. We didn't receive the copy of this. One. We have checked it up, so this copy has not been served.
You have served the copies, you take up the matter of some other day.
Yes, my lord. Let them test.
The petitioner is directed to serve the copy on the opposite parties number 1 through the Office of the Deputy Solicitor General of India, Orissa High Court, for 1 and 2, and also to opposite parties number 3, 4, 5, and 5, 7, 8 through Mr. D.K. Mohanty, the additional government advocate. So, let the matter be listed on 31st of August 2023. Mr. D.K. Roth, Learned Counsel, has appeared for the petition. All right.
Item 3.
My lord, the petitioners are Boda community, my lord. The petitioners are Boda community by their subcaste Boda. But the grievance of the petitioner is that, my lord. The subcaste of the petitioner not included in state tribal list, as a result of which the petitioner deprived of to get facility under the scheduled tribe community, under the state government. That is only grievance.
Whether the court can declare any community as a subcaste.
It is a matter of parliament, I think.
You have to approach the appropriate.
It is only the prerogative of the parliament.
That commission will decide.
I'm sorry, that will be approved by the.
My lord. And if he is a member, how is it a poll? PIL, I can't understand.
PIL can.
Your lordship may kindly see annexure 3.
You will not see any annexure, will be direct you to approach the appropriate authority.
My lord, one of the scheduled tribe certificate has already been issued by the Tahsildar Dikpahandi in the district of Ganjam, my lord. Your lordship may kindly see annexure 3, my lord.
Learned Counsel, come straight to the point. You yourself have stated this community has not been recognized as a scheduled tribe community, but you want such recognition. The court doesn't have power. Order has to be passed under Article 342. And that power is not with the court, it is with the commission.
My lord, the petitioner have already been given representation before the state government. Your lordship may kindly direct to state government to take a step, inquiry and investigation about the subcaste of the petitioner.
They can't do.
And maybe forwarded to.
No,
Maintainable also.
because it is an individual interest, we will not allow you to promote this interest here. You go file observing, you file to the appropriate authority. I think the nodal department is the Home Department in this matter.
STSC Development Department.
Vikas and Scheduled Tribe Development Department.
All right.
Government of Orissa.
But my impression is that it will be done by the
There
Home
is a
Department.
commission, I think there is a commission to look after, and
That is under the Home Department, both under the central government, the Home Ministry, and under the just.
Commission is under the central government.
central government. That is what I am saying.
You are Mr. Bodhraj Shet.
My lord.
And Mr. Bodhraj Shet and Counsel appearing with the petitioner. This has been styled as a public interest litigation for declaration of Bodha community, BODA, as the scheduled tribe. Stop. Just give the Constitution of India. In our considered opinion, this court doesn't have any sort of jurisdiction. So, a community is declared a scheduled tribe or scheduled caste by the presidential order after considering the appropriate materials regarding the ethnicity, etc. Article 342 of the Constitution of India clearly provides that the President may, with respect to any state or union territory, and while it is a state, after consultation with the governor thereof, by public notification, specify by the tribes or the tribal communities or parts of or groups within the tribe of the tribal communities, which shall for purpose of this constitution be deemed to be scheduled tribes in relation to that state or union territory as the case may be. It has been further provided by the clause 2 under the Article 342 that the Parliament may by law include in or exclude from the list of scheduled tribes specified in a notification issued under Clause A. Clause 1, any tribe or tribal community or part of or group within any tribe or tribal community. But, as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. In view of the visit provision provided by the Constitution of India, this court is divested of all powers to exercise its jurisdiction. As such, the petitioner shall approach the appropriate authority seeking for declaration of the border community as a scheduled tribe. So, in terms of the above observation, this petition is disposed of.
My lord, my representation may consider by the state government.
You go there because we do not have, we cannot lay our hands because of this 342. All right.
Appearance of power may be noted, my lord. The OP number 1 and 2 here.
2 also?
1 and 2. So wrongly they have implemented a home ministry, but
All
it
right,
is coming under tribal affairs.
Mr. P.K. Paril, and Deputy Solicitor General for the Union of India, just find out. Huh? And Mr.
I am appearing for other.
For the state. Yes.
Item number 4.
Yes, Mr. Mishra.
May I please? Lord, the present petitioners belongs to Kuneipada Mauja. They have filed a writ application before me, Lord, in the nature of PIL, because the government has established the bus stand in the Mauja that Kuneipada is very close to the bridge and to the under the CDS also the Commissioner Municipality. But renamed as Baranga bus stand. Baranga is 5 kilometer distance from Kuneipada Mauja. And there are 4 to 5 hamlet villages. Those are also under the Kuneipada Gram Panchayat. And they have been deprived because the name has been rated as Baranga bus stand, which is far from the place where the bus stand has been established.
This is also a public interest litigation.
My lord, in the nature that now the agitation has already been started in the Mauja of that all the hamlet villages. And the agitation is so long that because the
My lord, what
bus
has
stand
happened?
is at
Baranga is a big block, and there are many Gram Panchayats under Baranga block, and one of the Gram Panchayat is Kuneipada. And the department thought that this is the best place to.
yes, that is
But
there is no.
So far as the naming of the bus stand is concerned, it is named after the block. Baranga, everybody knows Baranga because it is, your lordship knows that from Cuttack to Bhubaneswar, it comes Barango, and that is a block, big area, very famous area. And Kunaipada is one of the village. And you should be happy that in your village, the bus stand is going to be constructed.
My lord,
So
we are not disputing that establishment of bus
for
stand.
example, if a lordship will see in Cuttack, a bus stand will be, it will be named as Cuttack
No,
bus stand, not
we are asking ourselves, why did this available court time will be wasted with the bus stand's name? How does it matter? You just take a decision after consultation with the thing. If you want to change, you have nothing to say.
My lord,
Take a measure and counsel appearing to the petitioner. In the garb of this public interest litigation, the petitioner has expressed the resentment for naming of the bus stand situated at Trisholia, Cuttack as Barang bus stand. Mr. D.K. Mohanty, Leonard, additional government advocate, has categorically stated that the name of the block is also Barang, and that is the reason why the opposite parties have named the bus stand as Barang bus stand. Stop. Mr. T.K. National Land Council has submitted that Barang is also a village which is 5 kilometers
5 kilometers from the place of
bus stand. Stop. I do not think that can give any reason to someone to come to the court in a public interest litigation seeking directions to change the name of the bus stand. Stop. However, we leave the matters to the consideration to the administration that they may change the name of the bus stand if they, in their opinion, that is required. But this is not a public interest litigation, which is absolutely frivolous in nature, according to the same stance, dismissed.
May I pray one thing, my lord? Before that, take decision, a public hearing be made.
No, nothing. We will not complicate the matter. We are not here to complicate the matter. We have given the state government a registration if there is the...
Yes, let the state government take a decision, but...
You represent to the state government, we have given...
We have already repented.
All right, they will take a decision.
My humble submission, my lord, that let them take a decision by hearing of the peoples.
All right. No, public hearing will not ask them to do that. Sorry.
More complications.
All right.
Item number 6.
Please, your lordship, my lord, in this case, the present.
My lord, the order of the single judge is under challenge in this writ appeal.
Yes.
Order was passed on 2nd January 2020, and the appeal had to be filed on 2nd within 2nd February 2020, my lord. That could not be filed because of his illness, my lord, suffered from illness. He recovered from illness on 5/5/2020, and thereafter, my lord, due to COVID-19 restriction, he could not file. He filed the appeal on 11 January 2021. That was within the exclusion period of by the order of the appeals court, my lord.
All right. Just right. INM 52 of 2021. And Mr. B.K. Mohanty, Land Council, appearing for the applicant. This is an application who is appearing from the virtual High Court at Jagat Singhpur. Jagat Singhpur. This is an application under Section 5 of the Limitation Act, Chapter 6, Rule 27 of the Orissa High Court rules, for condoning the delay of 344 days as per the stamp reporter's report in filing the intercourt appeal from the order dated 2/1/2022 passed by the London Single Judge in WPC number
2/1/2020, my lord.
Yes, 2/1, 2nd January
2020.
As passed by the London Single Judge in WPC number 834 of 20. This is also wrongly typed. You have wrongly typed 2002. Is it a writ petition of 2002?
Yes,
is it a writ petition of 2002?
Yes, ma'am.
WPC number 834 of 2002. No? Issue notice as to why the aforementioned delay shall not be condoned, or any other order or order shall not be passed as deemed appropriate in the circumstances. The notice is made returnable on 29th of September 2023. Steps for service.
My lord, excuse me, my lord, on behalf of the Union Bank of India, I am the standing counsel. Let the copy of the petition may
Alright.
kindly be sought. Ms. Tuna Sahu, my lord.
What is your good name?
I am Tuna Sahu, my lord.
Mr. Tuna Sahul and counsel has appeared before us on instruction of the opposite parties number respondents number 1, 2, and 3. And this is no formal notice is called for in respect to those respondents. But Mr. Sahul and counsel shall file his Vokalaknama within 3 working days from today. We request Mr. Mahanti, learned counsel, appearing for the appellant, to supply 2 copies of the writ petitions to Mr. Sahul and counsel within 3 working days. So the appellant shall take further steps for service of notice on the opposite party number or respondent number 4 by registered post with AD within 3 working days.
Respondent number 4 is also a bank officer, my lord, who has imposed the penalty, my lord.
What happened?
Respondent number 4 is also an officer of that Union Bank, my lord.
You have impleted him by name.
There is a private respondent. How can he receive that?
Yes, ma'am.
Take steps. Yes.
Item 8.
Obliged. Deeply obliged.
Item number 8. Item number 8.
Listed again on 16/8/2023. None appears in
Item 9.
Yes. Mr. Mudali, now you are appearing?
Yes, my lord. Yes, I have filed. One at Class A, IA number 2457.
I number 2458, I think.
One is IA number 2457 of 2021.
Yes.
That is filed for dispensing with filing of the certified copy. In the meantime, I have filed the certified copy, and that is available in my lord's record. That noting is there certified copy of impugned order filed.
No, he's not there. He doesn't know even maybe. Yes.
Just filed
Just take down is a 2457, no?
Yes, madam. 2457
of 2021. Heard Mr. P.K. Muduli, learned additional government advocate, appearing for the appellant. Stopped. Mr. Mudali has stated that after filing of this application, the certified copy of the impugned order has been filed
on 4/8/2023.
Filed on 4/8/2023. Stopped. In view of the above development, we allow the prayer for dispensation of the certified copy in filing the appeal on the order dated 16/12/2019. Passed by the learned single judge in WPC number 25586 of 2019. Accordingly, this petition can be disposed of.
The IA is at Flag B for condonation of delay of 707 days in filing the writ appeal.
All right.
And there is notice was issued. They have filed, the respondents have filed an objection also.
Yes, that is what. Who is appearing for the respondent? Who is appearing for the respondent?
Ms. Shashwati Mahapatra. Her name is reflected in the cause list.
Opposite party. But the opposite party has filed one objection opposing the prayer for following the delay. Let the matter be listed on 17th of August 2023 again for consideration. It is made absolutely clear on that day. If the representation is not available from the opposite parties, this court will decide the matter in absence of the said opposite party. All right, next.
Item 10.
May I please, Lordship?
Yes.
My lord, in the meantime, my lord, the respondent number 1 has been taken over by Orissa Mining Corporation. So just recently, so I'm moving this application for amendment of cost title. If your lordship kindly permit me to.
No, you file in the registry.
I'll file
I was
it.
fixing a next date.
Your lordships, it's just a formal amendment. So only the cause title has to be changed. Instead of IDCOL, it will be OMC.
OMC, that's right.
So that may be allowed, subject to the numbering
No,
of.
this should come through the registry,
right.
because there is some problem we are facing, not filing in the registry.
All right.
Let the matter be listed on. We are giving an as early date 24th of August. As it has been pointing out that the management has been taken over by who has
OMC, Orissa Mining Corporation.
Orissa Mining Corporation. Stop. The application for substitution may be filed in the meanwhile. You file it?
Then the court.
And so far as the counter is concerned, the counter is ready, but since that change is required, your lordships may extend that time, because on the last occasion, your lordships had
Alright,
said
in the
that
meanwhile,
let it be filed by 24.
the opposite parties may file their counter affidavit, taking care that the said change has taken place. Alright.
It's a modification.
Item number 12.
Obliged.
Supply copy in advance so that they can
I'm
take
supplying copy. I'm just right now.
Item 12.
My lord, I'm sorry to point out, sorry. There was a modification, rectification of the order, earlier order, my lord, that 10,000 metric ton is to be.
Already come on 24th, we'll decide.
24th, man. Great.
Item 12.
None appears, list the matter on. Huh? Notice there. 6/7 note, 6/7/2023 note. No? No, what is it? Order number 2 is something different. One, 2, and 3 only. All right. Registry has pointed out that due to late filing of the requisites, the notice could not be issued on opposite parties, opposite parties number 1, 2, and 3. Stop. The registry is directed to accept the requisites and issue notice showing the returnable date on 21st of September 2023. Stop. The appellant is directed to remove the defects number 7 and 9 as pointed out by the stamp reporter within a period of 7 days from today, else the adverse order will be passed by this court. Yes.
Item number 13.
May I please, sir?
Yes.
Madam, the informed order being without application of the judicial, the order dated 22/3/22 passed by the OJC number 11568 by 99. The Honorable Single Judge is contrary to law on suit filing the during consolidation operation in respect of the right title and interest over the suit settled land. And the impugned judgment dated
But your appeal is barred by limitation. So we have to issue the notice on your limitation application.
My lord.
I number 3601/2023. This is in hard Mr. You are Mr. P.K. Patra.
BP Oja.
You are on record.
My lord.
Yes, Vishnu Prasad Oja.
Vishnu Prasad Oja.
Mr. B.P. Ojal and counsel appearing for the appellant who has filed this application seeking condonation of delay of 252 days as per the stamp report.
My lord, the delay is only cause of the modification order in IN number 21/22. This order passed on dispose upon 3/11.
We are mentioning the stamp reporter report is the delay of 252 days. We have to be guided by that for the timing, unless you can show this is not a proper calculation, but on subsequent date you can show it.
Issue notice to the
we are issuing notice and filing the intercourt appeal from the order dated 14/3/2022, delivered by the passed by the learned single judge in OGC number 11568 of 1999. Stop. Issue notice as to why the aforementioned data. The same format we follow. Notice is made returnable on 29th September 2023. Stop. Since Mr. D.K. Mohanty, learned additional government advocate,
11 and 12.
appears in Webb's notice for the respondents number 11 and 12.
11 and 12.
No formal notice is called for in respect of those respondents, opposite parties, respondents/opposite parties. The appellant/applicant shall take steps for service of notice on the remaining respondents opposite parties by registered post with AD within 3 working days from today by registered post with AD. Take steps within 3 days.
Item 14.
You also there is a delay of 21. So I'm preferring this read appeal.
All right. Only the government opposite parties.
Lordship.
So I think you will know any objection, Mr. Bharat?
No, Your Lordship.
All right. In 388, huh? Heard Mr. Amitav
Pradhan.
Amitav Pradhan and it counsel appearing for the appellant who has filed this application seeking condonation of delay of 30 days in filing the intercourt appeal from the order dated 5/12/2022 passed by the single judge in WPC number 22181 of 2022. Stop. Mr. Arnav Behral and counsel appearing for the respondents which opposite parties has stated that the state will not oppose the prayer for condonation. So we have also perused the causes assigned in the application for seeking condonation of delay. So we are satisfied that the appellant/applicant has made out a case for condoning the delay, and accordingly this application, the aforesaid delay is condoned, and the result this application stands allowed. Next order in the appeal, in view of the order passed today in IA number such and such, we have taken up this appeal for consideration. Yes.
May I please? Your Lordship, in this writ appeal, the impugn order being challenged that is at page 57 to
66.
66, Your Lordship.
Yes.
The Honorable Single Judge has rightly observed the principle settled principle of law, your lordships. But while passing that order, he has attributed the delay and laches to the petitioner, your lordships. But my humble contention is that, your lordships, the delay cannot be attributed to the laches of the petitioner, as he has been approaching the opposite parties since 2007, when the date of publication of for the post of multi-purpose assistant, your lordships. 3 persons were selected, your lordships, including the petitioner. The petitioner was selected at serial number 3. He challenged the residential certificate of the petitioner number 1. On his insistence, your lordships, the residential certificate of the petitioner number 1 was cancelled, your lordships, and his candidature was rejected. Thereafter, he preferred the appeal. In the appeal also, the appeal was dismissed, confirming the order of the Tahsildar. Thereafter, he preferred the read petition, your lordships. All right. The first read petition. The first read petition was also disposed of.
No, according to the learned single judge, you approached after 15 years.
Lordships, after 15 years, he has not approached after 15. The read was pending till 2017, your lordships. The petitioner number 1, the candidate who had got selected at serial number 1, he had preferred a read petition. That was sub judice before this honorable court. Till 2017, that was sub judice. After 2017, when the read petition was dismissed, this candidature has got the preference, as he was the next serial list. The candidate who was in the serial list number 2 died in the meantime. So the serial number 3 automatically got the rights to be appointed as the serial number 1 and 2.
That is we like to understand from you. Where is his right to get to be appointed?
After 2017, he got the right accrued in favor of the
dismissal of some petition doesn't give right to you, because you are not selected. You are in the wait panel.
I was not selected just because of the fault of the petitioner, your lordship, just because of the fault of the opposite party. They could not
But you
verify
are not in the select list. You are on the wait panel.
No, I was in the select list number 3, your lordship. Not the 3 persons were selected, your lordship.
That is what you are saying. You were not selected. You were in the list, but at serial number 3.
After verification, the selection could have been made after proper verification of the documents, your lordships.
Yes.
But the opposite party could not verify the documents in time, your lordship. On the allegations made by the petition number 3, they initiated the proceeding. They could have done on their initiation, your lordships. They could have done. It was the responsibility of the state to verify all those documents properly. And the delay and the laches cannot be attributed to my humble submission, your lordship. The delay and laches cannot be attributed to the petition number 3, because he has not made any wrong or fault, your lordship.
Forget about the delay. What right?
No, just a simple question. If you say this is a selection list, how many vacancies were there?
1 vacancy was there and still persists, your lordship. Nobody can be.
And why are you saying that you are not in the wait list when 1 vacancy is there in the select panel of the 3 persons? Means serial number 2 and 3 are in the wait panel.
Lordship, but this petitioner he had also not been given the appointment, your lordship.
They cannot be given. After 15 years, government may think we go for the fresh recruitment, because what is the life of a select panel? Usually not more than 1 year.
They have kept it vacant just as the matter was sub judice before this honorable. They have kept in. They have not given any appointment.
It is not related to anything like sub judice, because your right cannot from the select panel after 15 years. Then every public employment will be stuck because of the select panel. And now some of the authorities already started practicing that we will not keep any select panel, whatever. Because what do you think, after 15 years, someone will claim right on the basis of a select panel?
What are you saying about the one at serial number 2? What happened to him?
He died in the meantime.
He cannot come.
the serial number 1, Pushpa Ranjan Pradhan,
Yes.
her appeal was dismissed by the Tahsildar in 2007.
Yes.
Then there was a writ petition filed in 2008 by the said Pushpa Ranjan Pradhan. No writ petition by the petitioner. That was disposed of in 2017. There is no mention of there being any interim order in that case. 6/5/2009, serial number 2 died. At best, his cause of action arose on 6/5/2009. So from 2009 to 2021, Your Lordship, there is no action by the petitioner.
On the initiation of the petitioner, all this movement took place by the opposite party. When the petitioner made a complaint before the authority, when the writ petition was pending, Your Lordships.
Who was in this select panel number 1? What is his name? The first petitioner?
Pushpa Ranjan Pradhan, Your Lordships.
The date chart, advertisement published. Cancer.
And second, who died?
Who died, Your Lordships?
6/5/2009. It's available at page 60 of the writ.
What is the date chart?
Page 19.
Akshay Kumar Pradhan, Your Lordships.
Internal page 19 and page 10 of the report. Oh.
Yes.
Where have you stated in your date chart that you made the complaint?
That is on record in the writ petition. Date chart I have missed. That is the page annexure 3, Your Lordships. And in the proceeding also, before the Tahsildar, he participated in the proceedings. He has made his deposition.
Okay, just a minute.
Lordship.
And what is this date chart after 2017, 2009 comes? After that writ petition by Pushparaj Pradhan was dismissed, he has made a representation for appointment in 2018. Oh, you gave a representation in
Lordship.
2018 and then waited.
In between Corona,
Waited for 3 years.
the period of Corona,
No. Corona came in 2020. You have given a representation in 2018.
We don't think, Mr. Pradhan, do you have any case dismissing your appeal?
matter of life and
No, just I'm telling you why. The advertisement was of 2007, right? Selection process was taken over. Some 3 persons were made in the select panel. Post vacancy was 1. So since the number 1 was not given any appointment, he filed a writ petition that was dismissed in 2017. Right? Suppose the writ petition was allowed. You have no case. Then suppose the select panel in the person number 2 has not died. You have no case. So your right is a contingent among the failing of these persons. And that cannot be treated as a substantive right to get appointment after 15 years from the said select panel. Got my point? All right. Learned counsel appearing for the appellant, also Mr. Ranna Vera, learned counsel appearing for the respondents. Stop. Pursuant to the advertisement dated 7/8/2007, annexure 1 to the writ petition, 1 Pushparanjan Pradhan, Akshay Kumar Pradhan, and the present appellant were put in the select panel against 1 vacancy in the post of the multi-purpose assistant under HON'BLE district. Multi-purpose assistant under DRDA HON'BLE district. So, according to the appellant, that he is entitled to get the appointment as person in the serial number 1 in the select panel, namely Pushparanjan Pradhan, has failed in his writ petition to get the relief from this court. Secondly, the person next to the person at the serial number 1, i.e. Akshay Kumar Pradhan, has died. So, therefore, the appellant being at the serial number 3 of the said panel is entitled to get the appointment after 10 years of the select panel, and that too on 2 contingent factors. One is failure of the person in the serial number 1 to get the appointment through the process of the court, and the death of the person at serial number 2. So, if we direct that the appellant has to be appointed, it would amount to giving an effect to a wet list after $15 years. Stop. The very purpose of the keeping a select panel is to fill up the vacancy which fell immediately after someone doesn't join or join the post on the basis of the selection or any other contingent that occurs immediately. So, but in this case, whatever the contingency that has occurred up to 10 years from the select panel, in view of the above, we do not find any infirmity in the order of the learned single judge, and hence this appeal stands dismissed.
And Mr. Behra, there's something in your guideline that list will remain valid only for 1 year, I think. So that also you could not have approached.
That is not on record, Your Lordship.
Item 15.
Single judge order. It is there.
May I prize something else? Liberty may kindly be given to give a preference to the petitioner when the fresh recruitment is done.
You are always entitled to, it is age barred. No, that is creating another right. Sorry, Mr. Counsel. Yes.
Item 15.
May it please, Your Lordship. Your Lordship, there is a 120-day delay in this matter.
$126 days.
Your Lordship.
Heard Mr. HON'BLE. In 1906, and counsel appearing to the appellant/applicant. So this is an application in Section 5 of the Limitation Act for condoning the delay of 126 days in filing the intercourt appeal from the order dated 14/11/2022 passed by the learned single judge in WPC number 18840/2022. Issue notice as to why the aforementioned delay shall not be condoned or any other order shall not be passed as deemed fit in the circumstances of the case. Notice is made returnable on 27th of September 2023. Stop. Steps for service on the respondent's opposite party shall be taken within 3 working days from today by registered postal AD. Next.
Item 16. If your lordship may kindly, my lord, may I place the matter? There's a content petition pending in this matter today.
Which matter?
In the item 16, in item 15. It's a simple matter, your lordship.
No, it's not a very simple matter. Anyway, we are issuing notice in our stay petition. This application number 2779 of 2023. This is an application for staying the further operation of the order dated 30/8/2022 passed in WPC OAC. This is WPC OAC number 1680.
Well, WPC number 18840 of 22.
The
8840 of 22.
Huh? Oh, this is sorry, this is 15. For staying the operation of the order dated 14/11/2022 as passed in WPC number 18840 of 2022. Issue notice returnable on the same day, huh? 27 September 2022. Steps for service of notice on the respondents slash opposite parties will be taken within 3 working days by registered postal AD. Stop. In the meanwhile, the status quo as in today shall be maintained. All right. We are not staying this till the next stage. All right, not till the next stage, in the meanwhile, huh? 16.
Item 16.
Item 16, there is an IA for condemnation of delay, 230 days delay.
All right. $300, 231 days.
Yes, ma'am.
Heard Mr. Pancake and Additional Government Advocate. This is an application under Section 5 of the Limitation Act for condoning the. This is IA 2778 of 2023 for condoning the delay of $231 days in preferring the intercourt appeal from the judgment dated 30/8/2022 passed by the London Single Judge in WPC OAC number 1680 of 2017. Issue notice as to why the aforementioned delay shall not be condoned or any other order or orders shall not be passed as deemed fit in the circumstances of the case. Notice is made returnable on 27 September 2023. Stays for service of notice on the sole opposite party shall be taken within 3 days from today. Stop. I think there is no further. You just do it. 3 days.
My lord.
27 September. Yes.
Item number 17.
Yes, Mr.
My lord,
Baker.
I filed a fresh IA for condemnation of delay. It's at flag E. There is 64 days delay.
Not copy, not serve.
Serve the copy, but will be taken on 16th.
File objection.
There is a content petition pending. That is my only worry, your lordship. The content petition is listed today.
We will stop worrying about the state who doesn't file the appeal in time and come with an application for condonation delay and presses that stay should be passed. We are passing to avoid the complications only, but that should not be a practice.
I deeply apologize. Your lordship.
So I'm just 21st is all right. Can you file within 7 days? Come on up to 7 days. Just on 21st of August 2023. Meanwhile, the opposite party is represented by Mr. You are Mr. Mahanta? You are Mr. Mahanta?
I am Sandeep Patnaik. S. Patnaik.
Mr. S. Patnaik will answer. Stop. The respondents opposite parties may file their objection, if any, by the next date. No further accommodation for the same purpose would be made. All right.
Item number
Correct.
18.
Some protection because the contempt petition is listed
21st,
today.
don't go for the contempt. Since you have received the notice, you know this appeal is pending. On 21st, you'll decide whatever way. Yes.
Item 18.
May it please your lordship. My lord, this matter you
Apply the moment is appeal filed. Okay?
item number 18, my lord. Your lordship may kindly see on the very face of the record there is no limitation, but limitation has been pointed out by the stamp reporter. Your lordship kindly see section 4 of the Limitation Act, my lord. If the limitation falls during the holidays, my lord, the reopening day would be there, and before that it is filed. That fact has been overlooked by.
Just wait. No. What is your point? That before on the opening day you have filed it.
No, before opening date, but limitation is the opening date. Section 4, your lordship may kindly see.
No, section 4 I should not read. You tell me what is the fact first. Go to the statute later on. Yes. What happened? Tell us.
Well, your lordship may kindly see page 40. Date of impugned order is 29th March.
Yes.
29th March 23.
When you applied for the certified copy?
Certified copy is application is 11th April.
Yes.
28 days. 28 days would be copy period. Page 42.
All right. Already you are delayed.
It is 58 days. If it is calculated from 29th March, it falls during vacation.
No. 11th of April you applied.
Yes, my lord. 11th April.
When the certified copy was delivered?
That was ready on 16th
May.
And the date of notification for filing fully is 9th May. So I will not get beyond 9th May.
No, just when the certified copy was ready for delivery.
It is 16th May.
All right.
11th 4, 16th May.
So the limitation will start from 16/6. Sorry, 17/5.
Yes, madam.
All right.
Yes.
Now 17/5 will get 30 days. But when it will fall on 30 days?
No, my lord, that your lordship may kindly see. I am satisfied. 29th March is the impugned.
First give the figures and then interpret.
Did you file?
Your limitation will start
in
from the
between.
17/5. Agree?
No, that with all respect, that may not be. Your lordship may kindly.
Why? Tell me, why not?
Your lordship may kindly see. 29th March is the impugned order. 30 days is for filing the appeal. Copy period is 58 days. If 58 days is calculated from 29th March, it falls during vacation.
No. Why don't you give the dates? Otherwise, it would have been 28th April. So add 20 days.
28 days.
This copy period will be added. Copy
So
period.
add that.
28 days if it is added.
So add and tell what.
Yes, 26th May.
26th May. Vacation started 22nd.
19th.
Doesn't know how to calculate your limitation. The stamp paper. No, but where is your certified copy? Whether 28 days are available? or-
Yes, 42, page 42. It is before.
Page 42. You applied on notification. All
Yes,
right.
that is there.
19 days plus 9.
Up to 9.
So not given that certified copy period. So here.
No, it says this certificate is 28 days is there. From the date of judgment, the real date of presentation is there. He finds the delay is 71 days. He says the 30 days and 28 days. You file during the vacation or after vacation?
During vacation.
During.
This is a practice creates a lot of confusion because any high court in this country
They'll get
doesn't
confused.
allow anyone to file
The confusion is that If you could have filed the appeal during the vacation, then you could have filed it within limitation. Why you are saying that the limitation will expire on the date of reopening? Because you availed the opportunity of filing the appeal during the vacation.
That is the problem.
That is the problem.
I
If
don't
you would
know
have
how that can be entertained also, that creates a lot of, because he was showing to this limit, section 4 of the Limitation Act, it's as taken a assumption that the during vacation no thing can be
correct.
filed.
No appeal is filed during
That is
vacation.
the problem. You cannot also resort to the section 4. Anyway, we are condoning the delay.
Yes, my
whichever
lord.
way.
Lordship may condone the delay and clear the.
It appears that the stamp reporter is wrong in calculating the days of delay, and he has not taken care that the limitation has expired during the long summer vacation of this court. But one fact this court also not oblivious, as the appellant has filed the appeal, presented the appeal during the vacation. Stop. Though Mr. Das, J.R. Das, learned counsel, was insisting that his appeal is covered by section 4, we are constrained to observe that section 4, provisions of section 4 of the Limitation Act cannot be applied, as the appellant himself has filed the appeal during the period of vacation.
During vacation.
Stop. However, considering the confusion, we condone the delay without any application, as in real term there is no delay. Stop. Just you now make your submission on appeal.
That matter, I would pray for 1 week time, 1 week for us. Because that is also another delay. This delay I have prepared, that delay.
Impugned order is very short. There was a previous proceeding, his father contested the case, suffered the order, and after his father's death, again the son is trying to postpone after. That is the order of the that may not be correct, but that is the order.
Come to the order.
Yes, your lordship may see the order.
Page 41 is the order.
Further, there is no denial by the petitioner that in the Sullings proceeding at the stage of revision, father of the petitioner was a party and was contesting the proceeding.
That
is
is
in this view of the matter, this court finds there is no reason to entertain such dispute after clear 1.5 decades. Entertaining such dispute after such lapse of time will be unsettling the settled positions in the middle.
Yeah. There are, on the very face of it, that two numbers of findings may not sustain, because if the writ is not entertained, everything would be unsettled. Because the impugned order, if it is worked out, settled portion would be unsettled. It is settled, the Honorable Single Judge says it is settled pursuant to Annexure 3 impugned order. No, it is settled since 74 pursuant to Annexure 2. 50 years back, my lord, the position was settled. It arises out of a sealing proceeding. My lord, 16 acres of land vested with the state. My lord, now the state wants, pursuant to the impugned order, further 2 standard acres, which has been settled under possession for a period of 50 years, my lord. Now, if the writ is not entertained, was not entertained, everything would be unsettled if the impugned order is given effect to. And the other finding that father.
We heard the matter on merit, you come on please in the 1st of September. Always.
First?
1st of September, first day of September. Only let the appeal be listed on 1st of September 2020 for consideration on merit at this stage. Mr. D.K. Mohanty. There is a private respondent.
Private respondent is there.
Private respondents are there. The state is the more contesting, but
no.
Private.
Mr. D.K. Mohanty, an additional government advocate. Has appeared for the opposite parties, respondents number 1 and 2. All of you see.
Well, I pray for status quo, my lord. I am in possession.
Sorry.
Item 19.
Then, my lord, your lordship, I will confirm one aspect of the matter. The other, my lord, the input order has not been worked out. My lord, it has been directed that the property would vest with the state. State would be the affected party. Other parties, my lord, though they are name lender, my lord, they would not be affected either way. So, your lordship, I will.
1st of September.
Yes.
1st of September.
Yes, that
Yes.
is the reason why you have given you a short date.
Yes, yes.
And
Yes.
I was asking you to make your submission, you say is another date.
Yes. Yes, yes. If that was, then I am not pray for an interim order. Let it be on that date. I would make a prayer.
1, 2. For consideration of admission. Mr. Manti has already appeared on pregnancy notice, huh? Yes.
Item 19.
May I please, Your Lordship? Now, this appeal has been filed by the state. I have filed 2 IAs. One IA at flag A 3962 of 2023 for dispensing with filing of the certified copy. So, I pray Your Lordship may grant me some time. In the meantime, I will file.
Certified copy has been received.
I have not received, Your Lordship may grant me some time. I will.
All right. At the request of Mr. P.K. Mudoli, Learned Counsel appearing for the appellant, let the matter be 1st April.
Your Lordship may grant me 3 weeks time. In the meantime, I will file the.
All right. Then go on 14th of September 2023.
By that date, I will file.
No, because there is an issue unless the certified copies and the dispensation is not done. The delay will be separately dealt with. On 14th of September again.
Must have given the offense. Contempt is pending. My
My lord, I have
lords
not-
have issued notice. My
My lord,
lord,
they
last
delay-
occasion, my lords have issued notice in limitation matter. Delay of 60
My lord,
days.
in pursuant to the my lord, notice on limitation, I have entered appearance for the private respondent no 1.
Oh, yes.
My lord, at present, I am not pursuing the content since the matter is before my lord's my lord.
That
And to the my lord, limitation application, I will file an objection.
Filing.
Yes.
the lordship may record his statement that he will not pursue the content.
No, that already I cannot give. I will not pursue.
Even
But
if
my lord, the
pursue,
state.
unless the state simply said that we have filed an appeal against
Yes,
the order.
yes. My lord, say, intra-court appeal.
If even if the judge is not satisfied with your submission, you just simply record this. All right, get it recorded. That's all. That will do help you a lot because there's a very precise Supreme Court decision. Any contempt is the basis of the contempt is the deliberate violation. When you are pursuing an appeal, that this element of the statutory requirement goes diluted.
The view is, my lord, unless there is stay, you have to comply.
No, but stay will not pass. You come, then I shorter order date you can. I do not know why you cannot collect the certified copy. Because I am told by the registry that only 3 days they take for supplying the certified copy. If you do not apply, how the registry can help you out?
Stated it had already been applied for.
It is being stated that since it takes 3 days for getting the certified copy, what is your problem in filing the certified copy? You have to control your staff who apply for the.
You just counsel, there is a request from the court, you don't pursue the.
Yes, my lord, I will not pursue.
We are not also reflecting this because that may.
Well, in fact, after getting the notice, I am not pursuing the contempt.
Always.
Yes.
All right. I will remember this.
But it's a intra-court appeal, my lord. Even if I pursue the contempt, it will not.
Exactly. That is why I am pointing
Yes,
to the
yes.
government advocate. I do not
Yes,
know why they feel helpless.
They made a Union of India is a former from opposite party.
We will definitely record you, don't worry.
Only copy maybe, sir, we don't have any copy.
What is the learned counsel?
Yes. One thing on merit of the matter.
Definitely.
No, today I am prepared just only to apply. Well, here is a case, well, though the constitution prohibits for inclusion of any caste.
First, the limitation is to be considered.
Yes, now the direction has been issued by the Honorable Single Judge. You state should issue a clarification declaring that a caste is a subcaste of another caste.
No, that is not
the
correct.
direction.
That is not correct.
Yes, but here is a mandate.
Yes.
Okay, but here, my Honorable Single Judge directed you issue the clarification that this caste is a subcaste of. Yes.
Well, in fact, the Union of India has also a great role in this matter because the Union of India has. Yes. My lord. Exactly, my lord.
Here, SCBC.
But here, my lord.
Yes.
Yes.
But this statutory commission has also rejected.
Item 3, my lord, is
My lord.
After the presidential order published in 1950, inclusion and deletion of the list requires the parliament's consent.
Yes, my lord. Yes, my lord. Your lordship. No, today, similar matter, your lordship disposed of today. I was
here in the instant case, statutory commission has rejected
but
such
it's
a
a
claim.
different matter altogether, my lord. Yes. Yes.
Yes, sorted,
Yes.
my lord.
My lord. My lord.
Yes.
Watch. List watch. My lord, respond number 1.
others in the Union of India in appearing, but I didn't have a copy that's it.
How many days delay?
68.
68 days.
Two and four.
2 and 4 or 3 and 4?
So 2 and 4. Yes, 2, 3 and 4. All. 2, 3. But Ministry of Education, Government of India, 2. Sorry, 3. 2 is Union of India.
Yes, for now.
2 is Union of India. In the appeal memo. Yes. 1501. State of Odisha, it consists of 8 appellants.
Only respondent side.
Item number 21.
Oblige.
Item
number 21. Lots.
Let me kindly see the order dated 25/4/2023.
25/4/2023, my lord. Para 6 of the order may kindly be seen, my lord.
Order number 36.
36. Yes, my lord.
My lord, we can see paragraph 1, paragraph 4. 4, 6 and 7.
25/4, my lord. 25th April, my lord.
Why is that order just check up? This order is not.
No, 25th April.
Maybe
It's an
this
order.
not a scan. We're checking in the physical report. Any
We
order?
have obtained the
There is
print
order.
out from the word.
Just mark it, huh? Mark it for scanning all that.
I've got a copy, my lord. I've got a copy. Can I hand it over, my lord?
Yes, no, this. You are referring to paragraph?
Paragraph 6, my lord.
What are the three amicus curiae?
Lordship,
You are
with,
three.
my lord, Mr. Gautam, Mr. Senior Counsel, Amirath and me, my lord. We three of us are the
So what
amicus
happened?
curiae.
Have you?
We had submitted the report, my lord, highlighting that what are the gaps.
All these colonies.
My lord, these colonies, my lord.
When have you filed that report?
Your Worship, the latest report is there. Your Worship is fine. The latest report is nothing is referred.
No, it is not shown in the noting, my lord.
But Your Lordship, it's there. We've all filed and it's there. It must be the last flag, Your Lordships.
Not flag 59?
59. Yes, Your Lordship. Yes, Your Lordship. One is 57. Raulkela is 57. Flag 57.
Jharsuguda is 58.
8.
Bargod is 59.
Yes, this was the latest visit we had made. And Your Lordship, I should bring one thing here to notice that before this date could come, the two meetings, they were also a meeting which is happening.
Yes.
Where we have the different departments who sit. These reports also have been submitted to them beforehand. So all that they have to probably today show is the compliance, and Your Lordships will kindly look at the report, Your Lordships. If Your Lordships will take up the Jharsuguda report, which is at flag 58. We also have the entire proceeding in a pen drive, video and photographs also, but some relevant portions also, Your Lordships. Your Lordships, in Jharsuguda, we found, if Your Lordships will look at that report, page 2. Page 2, Your Lordship, there were 5 colonies involved.
Well, in fact, there are 3 reports have been filed by the amicus curiae.
All copies have been served, sir.
Now I have been supplied with copies so far as Bargod district is concerned.
No, all of them have been served.
No,
Your
no.
Lordships. All
Only
of
one
them
copy.
have been served.
Only one copy I have.
So because we are presently on the Jharsuguda report.
That is not supplied to me. Jharsuguda and Raurkela have not received the copy.
But the department have been, because the system here is that there is even our committee is also sitting, so all the reports have gone there. Mr. Mahanti also, Ishwar Mahanti is also part of that committee. He's been also attending with us. Ishwar Mahanti, he's also attending from the government side. He's attending. He's been given the reports. I mean, if you go into the dispute, then that's a difficult. But you also look at the report.
No, I want
that
if
report.
there is any deficiency, that should be complied with.
No, I'm just
Because
saying,
I
Your
have
Lordship,
received the copy.
there's an urgency
Forwarded is
involved.
forwarded-
There are certain urgencies involved. Certain colonies here don't have proper bathrooms. So I think I don't think that's a problem because these are all photographs.
Just come to the church, just we'll supply you copy.
As far as the Premanivas colony is concerned, Your Lordships, it's not much to be done because this was actually run by a missionary. And there are only 2 people there, they're well taken care. So it's now.
And these colonies are also being funded by the government?
Most of them have missionaries running them. 1 or 2 of them have government settled land.
No. Problem is, Miss Rath, that suppose these are exclusively run by the missionaries. And they can easily say that we don't have funds to provide.
No, Your Lordships. They are not exclusively run by missionaries. Some of them have been gifted land. In some cases, the government has
also
settled.
the government can provide funds.
Yes, and government has intervention. For time to time, they go there, they do because the medical checkup and everything is done by the government. So they are well monitored by the government. And in fact, probably in that area, Jharsuguda fares the best among all the other 2 districts. Your Lordship will look at Premanivas colony. I would not press it. There's not much to do. Indra Ashram, in fact, is one of the most government-controlled colony there. But Your Lordships, there are some suggestions, like there are issues with housing. Some of them are very dilapidated and they really require concern, and with this rainy season. And Your Lordships, all of them have insisted on mobile bank. The reason being that these people are giving pension, either that 600 or the 800 pension under the government scheme. But Your Lordships, they don't have, they are either in an armchair or, traveling is a difficulty for them. In fact, in Puri, we had made the same arrangement. There used to be mobile banks who used to come and disburse that pension. So we recommended because there's a huge lot of work which is done in Baleswar, Puri and other places.
You mean to say they're getting pension, but getting hold of that pension is a problem?
Yes,
So
some
they
of
have
them
to go
don't
there.
go. Yes, Your Lordship. Some of them don't go. And then Your Lordship's skill development.
That we want a very quick response over the suggestions made by the amicus.
Very reasonable also.
Yes. It's a very minimum
definitely-
requirement they are pointing at. Mr. Mohanty, you are the part of the process, I'm told.
Please, my lords.
What is the response of the monitoring committee?
Well, as the monitoring committee on the last occasion, on last meeting, there were presentations given by different districts. And thereafter, my lords, the amicuses had produced 3 records, 3 reports based on their visit to certain places. Those reports have been communicated by me to the department. And thereafter, my lords, these affidavits have been filed. Now, my lords, we have to see that there are certain things.
You are meant to referring to the affidavit filed by the additional chief secretary?
Please, my lords, the additional chief secretary.
Okay.
That has been filed.
Have you received the copy of the affidavit of the additional chief secretary?
No.
Ms.
So,
Ross?
no, after these reports, there is an affidavit.
No, my lords, the affidavit that was filed before, my lords, on the last occasion.
The reports are available.
The reports.
No, we don't bring this to the past stories.
Please, my lords.
They have filed and they have made certain very categorical suggestion in the reports.
Please, my lords.
We want a quick response from the state. We are fixing the matter on 21st of August.
Please, my lords.
Because this is a rainy season, some issues are very, very pertinent to be addressed right now.
Please, my lords.
Right?
Please, my lords.
By 21st, we are fixing, we want a report from the department.
Please,
May I please, my lords?
And somewhere the missionaries are operating these areas and colonies.
Please, my
You have to arrange fund for them, but you can also monitor when you will be funding these things.
Please, my lords.
So these are taken, you also mention your response.
May I please, my lords?
Please.
And in fact, Lordships, I must bring to notice of this court that when we did visit Baleswar, things were very bad there. Somebody was about to die. And by the time we came to this court, she died. That person died. The court really took note and there was a huge intervention. All of them were, transported. They all came to SCB, well dressed, taken care. They went back. So a huge lot of work has happened in Baleswar and other with the intervention of this court. Baleswar did not, in fact, have proper living buildings. So now new buildings have come up. Everything is there. That is being side by side monitored, but
That is the
court,
purpose
yes.
we do arrest, because
Yes,
it is not an adversarial litigation.
Yes,
You
but
want
it
to
is
use
last-
it, you are
yes.
providing the, what is their response? Then
Yes,
the court
yes.
may also direct, may not direct. If the consensus raised, the government will do. We'll only fix a time frame that by
Lordship.
which date they should construct building or provide the amenities and other facilities.
They
that
have,
are
because there,
suggested.
yes, there are various actually government schemes for housing, for clothing, that there. It's only to be implemented.
May I please, Your Lord? My Lord.
Yes.
My Lord, I'm on behalf of the petitioner, Your Lord. My Lord, I haven't got the reports that my Lord and seniors are talking about. Your Lordship, this problem is a menace. It's increasingly becoming a menace. And the real reason for the menace, for the spread of the menace, is yet to be taken care of. Your Lordship.
Why do you call it a menace?
Because it is increasing, dividing. And
What is increasing?
the leprosy?
Okay.
Instances
So
of
you're saying medical.
the instances of leprosy. Your Lordship,
don't term is a menace.
it is actually as my Lord and seniors.
No, you're not saying that. It is a question of management. So
All these statements are without any.
There are people
document,
who, are, these people are ones who have been historically deprived from their living
My Lord, my kind. Under this Honorable Court's judicious direction, great amount of work has been done under the suggestion of amici curiae. I accept all. But my Lord, the only aspect that is yet to be taken care of is the personnel part of it. All that have been talked about are infrastructure that is absolutely needed. But Your Lordship, there are specific manpower required in order to man these infrastructure to take care of this specific disease. Because this is a specific disease, it requires specifically trained manpower. Your Lordship.
Probably my untrained has not gone into the affidavits which have been already filed.
My Lord, the affidavits, I have few of the affidavits that have been filed, I have gone through. There are
no, not the these amicus affidavit. Not the amicus affidavit. Perhaps Mr. Mudali is reporting to the filed by the government.
Yes,
concerned department.
government as well as concerned district magistrates have also filed, indicating how the treatments are being given and the persons who are responsible.
But he's on a more broader issue.
My Lord, there are
to that respect also.
Just try to understand that there's a human issue. Everybody's status is not on the equal platform. Some require immediate attention. So that unless inside there was some personnel, where paramedics in nature can take immediate care and thereafter taking them to the specialty hospital where
that is being done.
You are saying as if we are living in the heaven.
No,
it doesn't happen. We have the practical experience in the field.
No, so
Lords, may kindly see my report. The report, Bargod report. Lords, may kindly see the photographs.
Okay.
No, Bargod, since it copy was supplied to me, I have obtained the instructions. Yesterday, I have received the instructions. The Lords may grant me liberty. I'll produce those instructions.
No, not instruction on 21st, but file an elaborate affidavit by 21st.
So far as Bargod is concerned,
all the three reports.
Yes.
Not only instruction, will do file an affidavit.
May I pray, my lords? May I pray, my lords? My lord, there are specifically 404 posts of paramedical workers trained in leprosy treatment assistance. They are lying vacant. The government is, resisting.
Do you have
that is a different cause of action, and they.
You have the information. There
my lord,
posts are there.
My lord.
So that we can ask them to take instructions. Is it oral submission or is there somewhere on record?
There on that decision has been taken by the government not to fill up the post because in view of the National Leprosy Eradication Program, the posts are not being filled up. It is being managed by the general healthcare system.
Yes, to avoid that segregation principle, what they did, they wanted to mainstream it. Because it's not that infectious as people think it is. So they wanted to mainstream it. So physiotherapy can be put. And this issue was actually raised by the earlier councils. And I think there's some orders which the court has taken care. So all that the court said that time was that, you have continuous visit of doctors, which is actually now happening. We have continuous visit of doctors. And in fact, all the suggestions that we give are not on what we observe, but completely on the statement of the people there. So that's why we have recording to that. They have said that they do come once a month. Today, in fact, they provide the system today is you provide a kit so that they help themselves immediately. Because the disease is actually a skin disease. And it loses its the power to feel sensation. So because of which, even if you are cured, there's a chance of accident. They won't make out the difference in hot and cold, rough and that's the reason.
They get injured easily.
Yes, Your Lord.
May I please, my lord? My lord, I may be allowed 1 week time to file my part of the story.
While we are fixing the matter on 21st of August, this.
My lord, may I submit? There are 404 posts.
You file an affidavit.
My-
File an affidavit. All right.
Because once that
I
aspect
beg
is
pardon,
done,
my
my
lord.
lord,
I am on a BC, my lord. I am for OP number 4 and 7, my lord.
All right. We are fixing the matter on 21st of August. Let this matter be listed on 21st of August, 2023. Stop. We direct the state to file their response elaborately, having due regard to the 3 reports filed by the no, it is a group of the amicus curiae on this, the report on the Replosi colony situated in the Jaisaguda, report on the Replosi colony in the district of Bargar, and the report on Raurkela, yes, and the report on leprosy colonies of Raurkela. On perusal of the report, you find that the said group has made a specific suggestion which are required immediately implemented. Stop. That apart, it has been pointed out that in some colonies, the housing and sanitation is a problem of serious proportion. So the state shall also come out with a specific plan how this gap can be filled in a shorter period of time. Stop. After the response of the state is available, after supplying copies to the amicus curiae, namely Mr. G. Misra, Senior Advocate, Ms. Pami Roth, Senior Advocate, and Mr. B.P. Tripathi, Advocate. Stop. Oh. All right. Dr. B.K. Misra has been visiting the court, appearing for the causes of the leprosy patients in the state of Orissa, which has been brought before this court by the petitioner. Stop. We also permit the petitioner to file an additional affidavit on those 3 reports or any other additional issues as the petitioner.
I don't have the reports.
We'll provide.
About.
We request Ms. Pami Roth, Learned Additional Senior Counsel, to make it convenient so that the counsel for the petitioner can get a copy of all the reports. All right. You have to say anything? All right.
One other thing, I didn't want to interrupt your lordships. Apart from the relevant pertinent issues that my learned senior picked up regarding the deliberated conditions of the house and the sanitation, in the reports we have also provided the details of certain individuals in individual leprosy colonies who are in urgent requirement of medical attention, your lordship. So if that also can be dealt with by the state, specific details of these persons in individual colonies we have provided.
Also, already you can also file an affidavit.
In
this matter,
take follow-up
there is
action and report regarding medical. Why should you wait?
Your Lordships, I can, I think,
say what you have done.
I'm appearing on behalf of Mr. Bishop.
Right, we have taken their report into consideration. The group of three amicus, they have visited the three districts for visiting the colonies, and the basis of we have not elaborated on our order, what is the report saying. Because we are exchanging the reports to the interested person, including the petitioner, then their response is very much important, because the response of the government will be of utmost importance.
That I bow down
their
to.
response, we cannot proceed further.
The only thing is that this medical issues those people are putting, government may take up steps instead of just filing a reply.
It is categorically stated by Mr. Modi, the steps are being taken. So if you find there is requirement, but the steps are not being, illustrate a particular incident so that we can just hold the government responsible.
In our report, actually,
Your Lordships, we have the head of the
specific
monitoring committee, because that's the order. Every time this sitting every time the date happens, the head of the monitoring committee is also present. Virtually, she's present, Your Lordships. So that also, that the local CDMO can always be asked to visit. Virtually, Your Lordships will find the SPED is there.
SSCPD department.
SSCPD department is there. That's the.
Yes.
Of course, I think the chairman is not there, but at
you
least.
heard this is one difficulty has been pointed out regarding the medical attention of this leprosy patients who are living on those colonies.
Urgent need of medical attention.
You please take care of this.
Are you able to hear?
No, I don't think they're getting us.
I think the additional secretary of the SSCPD department is here. The chairman is not here.
I think they are not hearing us.
Yes.
Madam, her name, please.
Additional secretary Madhusmita Manti is there.
Madhusmita Naik.
Can you hear us?
Madhusmita Naik.
Can you hear us?
Already the rest will take on 21st.
Regarding that medical attention, please see that in the reports it is some patients, it has been mentioned they are in urgent need of medical attention.
In fact, to that extent,
Please see if it has been done, or please do it before the next date.
in fact, so far as Bargad is concerned, I have received the instruction that a dresser has been appointed in the colony out of the district Red Cross fund.
What has been appointed?
Dresser has been appointed. Dressing is required.
For these things, these paramedical workers are needed. That's what
that is why you was pointing out 400 vacancies are there.
There are provisions, and government, central government has
A decision has been taken to abolish since 2001.
So they have abolished it.
Have you mentioned that?
They have already filed the affidavits. Same issue was raised by another NGO.
Containing all the affidavit. And budget being allocated, but people are not.
That case is pending or disposed of?
In this case, an IA was filed by an
We are
NGO.
going to the next item. Just to take the matter up.
Item 22.
Well, instead of 21st, may I pray, Lord, grant me one more accommodation till 23rd. Because as
23rd.
Yes, from my instruction from Bargad district, because they have fixed the deadline till 20th of August to comply, to supply those.
All right, 23rd, maybe.
23rd.
Yes. All right.
Item 22.
There is some matter, sir, is 12:30, is mentioned. Anyway, taken up that.
Order of this Honorable Court dated 2/8/23, my lords. In fact, we have already filed our affidavit, and that we have completed our work since December 2022, my lords. And the system of this very system has been commenced since that date. We have filed this affidavit by Water Corporation.
20.
When you file the affidavit?
We have filed this affidavit.
Flaggy. Copy not served.
This, you are for the opposite party number 9, I think.
Mr. Bhuya, are you opposite party number 9?
Yes,
Then it is.
Water Corporation Limited.
Yes, Water Corporation Odisha, Water.
Right, whatever, yes.
We have completed the rest of the work since December 22. Although we have promised on to complete by.
You have completed the work.
Yes, my
Is
lord.
the remaining part of 2.3 kilometers?
Yes, my lords. We have completed the entire area, my lords, and that system has been commenced.
You come to your paragraph 2, sir. Paragraph 2.
Yes, my lords. That in fact, the Watco project division 2 has completed the rest work 2.3 kilometers gravel network of sewage system of Lakshmi Sagar area since December 22. And the said sewage system in the area has also been commenced for public interest. In this aspect, no complaint has been received by the
Comments
any household so far.
completed and comment.
No, your statement was that they have completed. Where is that statement that they have completed the efforts that were till date in Lakshminagar area? There is a para 3. Para 3 statement you are referring to?
Yes, my lords. Para 2.
No, para 2, they trying its level best. It should be the level best to complete the rest work of such and such by August 2022. So come to the para 3 of your affidavit that you filed last.
No.
Okay, sorry, there is a. All right. Now, who is appearing for this petition?
Petitioner.
They have completed it.
My lord, in this case, the viewers of the petition before Lord seeking for
Complaint they are saying.
for complaints of sewage and drainage. And so far as the sewage is concerned, opposite bed number, and it has converted to opposite bed number 3. What is now opposite bed number 9. They have
drainage is not this obligation of the respondent number 9. Drainage will be looked after by the separate division. I think it is the corporation.
BMC.
No, BMC, Watco also we have that other
Yes.
PIL is there where Watco
What?
we have made it an opposite party
Yes,
number 6. That is probably posted to 21st. Mr. You are appearing for the sewerage board, Mr. Bhuiya. There Watco has been made opposite party number 6. Last date you were not present when the matter was listed. That
No, Mr. Das is
Lord, I am appearing for Odisha Water Supply Sewage Board and Mr. Bhuiya appears for Watco.
no, his name is there for sewerage board. That is the thing.
My lord, so I'll
That
check.
case is probably posted to
You are
21st.
appearing for the water board now.
Yes, ma'am. Now,
No,
the
sewerage board. He is
Sewage
Watco.
board. He is
Okay.
appearing for the sewage board. He is appearing for the Watco.
Okay. So whose responsibility to make the covert drains and for purpose of these managing this huge flood water?
my lord, initially that was entrusted to the Odisha Water Supply Sewage Board. Now, after 2019, my lord, the entire operation and maintenance of all this sewage work is concerned, my lord. It has been transferred to Watco. And so far as drainage work is concerned, my lord,
We are now because they have filed the affidavit that the sewage system has been commissioned.
Yes.
And entire this gravity network is in operation. So they have made a very positive state.
Yes, my lord. So till
functionality they will look after. But we are talking about now the drainage system.
drainage, my lord, Bhubaneswar Municipal Corporation,
my
my
lord,
lord, they
my lord,
can
here
answer.
in this case,
This is why I'm telling you this is a municipal corporation's responsibility. Who is appearing for the municipal corporation?
I'm appearing on behalf of Mr. B.K. Monte for BMC.
So what is your response?
Our role is limited.
Your role is limited to what extent?
Your Lordship.
You can have a role, you can have a part role, you can also outsource the construction of the drains to some agency. But ultimately it is whose the primary role to maintain the drainage and construct the drainage for the passing of the huge rainwater.
Pardon, Your Lordship.
You have no idea. You are appearing in a public interest litigation. We are fixing the matter on 21st. You just, Mr. Mohanty, you just coordinate and find
My
out.
lord, your lordship may kindly see an affidavit filed by the additional chief secretary on 12th July 2020. Additional chief secretary. has
Which is
filed
that?
12th July 2022.
22 or 23?
22, madam. It's an old affidavit, but para 6 is important.
Which is that affidavit? Not properly marked, we are unable to know. 55. Storage board again.
If your lordship will allow me, I will read the relevant paragraph of. This is the additional chief secretary has filed this affidavit herself.
Cannot page marking the affidavits also very difficult to find.
That it is humbly submitted that after careful consideration, it was decided by government and an unified and dedicated drainage division under BMC, Bhubaneswar Municipal Corporation, has been created by the government in Housing and Urban Development Department by notification so and so so and so. Consequent upon creation of drainage division under BMC, all the works of drains except Gangwa Nala, Buddhi Nala and Puchidhara Nala, Pachidhara Nala, which are under the drainage division of water resources, have been transferred to the control of BMC as per the joint meeting held on 27/1/2017 between the officers. Has your lordship got it?
Yes, yes.
Yes. Housing and Urban Development and Water Resources Department under chairmanship of the Commissioner cum Secretary Government. Housing and Urban. As per the decision in the above meeting, all the natural drains of Bhubaneswar city, which were under the drainage division of Water Resources Department, have been transferred to the BMC since 2017. Since then, all the construction work along with the operation of maintenance work are being taken over by BMC in the interest of state. Copy of the notification, so annexed by 1. That in view of the aforementioned facts and circumstances, the opposite part number 1 is nowhere. So this is the status of 2022. And thereafter, BMC has 2 agencies, this WATCO and the, so they have to, as per the affidavit of
But it is the primary responsibility of the Bhubaneswar Municipal Corporation.
Yes, primary responsibility, as per the notification.
You are the counsel for the Bhubaneswar Municipal Corporation?
My senior, I'm
So where is your senior? Because this is a
He's
serious
on
matter.
accommodation.
Sorry?
He's on accommodation, so kindly keep it
Oh.
to some other day.
When will be coming back?
By Monday.
The accommodation.
Mr. D. Mahapatra?
Mr. P.K. Mohanty, senior counsel. Mr. Pradipta
What
Kumar
is your name?
Pradipta Kumar?
Mohanty.
He was there. Yesterday he was there. Yesterday he was there.
And your good name is?
KT Mudali.
KD.
Yes.
Okay, D. Mudali.
KD or KT?
KT.
KATY.
No, K and T.
K full stop T.
Yes.
MS KT Mudali, Learned Counsel.
Beg pardon, my lord, we are appearing, I am appearing along with DSJ, my lord, for Union of India. For Union of India, along with DSJ, my lord.
Learned Counsel appearing for the on instruction of Mr. P.K. Mohanty, Learned Counsel for the Bhubaneswar Municipal Corporation, has prayed for some accommodation. So, in the affidavit filed by the opposite party number 1 on 12/7/2022
at para 6.
clearly stated that Bhubaneswar Municipal Corporation is in charge of the construction of drainage, its operation and maintenance since 2017. See para 6 of the said affidavit. Stop. Only the Bhubaneswar Municipal Corporation, BMC, has the authority to take up any action regarding the drainage, the management of the rainwater, etc. We direct. It has been stated by Mr. D.K. Mohanty and Counsel appearing for the opposite party number 1. The Bhubaneswar Municipal Corporation ordinarily commissions 2 agencies. You are representing opposite party.
Copy number 5 and 6. What is the water supply storage?
What is the Orissa Water?
Supply and storage board.
Agencies namely Orissa water supply in Suarez Port and the Orissa Water Commission, Water Corporation Limited.
Yes.
Respondent number 9, first one is at 5 and 6. Stuff.
Your Lordship may note this. I may be forwarded. Page 4 of that counter affidavit, first para, last 3 lines. Page 4, that is the government affidavit. First para, last 3. Since then, all the construction
That I
works.
have already taken note of. I have already quoted this part.
Operation and maintenance.
Oh,
Yes.
Construction, operation, and maintenance,
Yes.
3 aspects. All right.
My lord, I may beg pardon, my lord, I am on VC. You are appearing along with DSJ, my lord, for Union of.
All right, you are interested in recording your appearance, we will record it, we are passing the order, please keep quiet.
No, my lord, what your lordship will ask, I will.
What to do with this council?
Why are you disturbing when the order is being dictated, Mr.?
Stop. The opposite party, number 9, Orissa Water Commission Corporation has filed on affidavit on 8th August 2023, where they have categorically stated that WATCO project division number 2 has completed the entire gravity network of Suarez system in Lakshmi Sagar area in the month of December 2022, and presently the Suarez system is totally commissioned and functioning stuff. According to Mr. Bhuiya, Land Council representing the WATCO, that their part of the project is complete. Stuff. But the Orissa Water and Suarez Board has not filed any affidavit.
No, we have filed, my lord.
Where is that affidavit?
Lord, 7th of March 2022.
7th of March
2022. Lord, the swear in our.
You are also appearing for 4 also.
Yes.
Then 4 and 5. Stop, just slow. The opposite party number 4, 5, and 6 also filed the affidavit that you filed on this date.
The 7th of March 2022.
7th of March. Okay, that is only by the opposite party of 5. Yes, not 5 and 6. The opposite party number 5 has also filed a separate affidavit on 7th March 2023 and stated that the Orissa Water Supply and Suarez Board was entrusted with the responsibility of construction as well as operation and maintenance of all Suarez and septic system by the Housing and Urban Development Department by their resolution dated 25/11/2017. As such, presently they are responsible for construction as well as operation and maintenance of all Suarez system in the city of Bhubaneswar. But the Suarez part has been handed over to the Water Corporation of Orissa, WATCO. It has been stated in para 5 of the said affidavit. the area in question, I Bagagur Colony, is coming under Lakshmi Sagar Suarez pumping station of Suarez District 2, wherein the Suarez line to the extent of 2003 meters has been laid and 7 numbers out of 10 numbers of manhole chambers have been completed by the Watco. No, sorry, Orissa Water Supply and Suarez Board till 31/10/2023. Stop. We would ask the Bhubaneswar Municipal Corporation to send a team consisting of the technical persons who have the competence to make assessment whether the construction of the sewage system or the drainage is adequate to manage the excess flood water or the rainwater during the rainy seasons, and whether the sewage system that has been commissioned is properly functioning. And they also state clearly that whether the people of this area have any further complaint regarding the drainage and sewage system. Stop. The said technical team shall visit within 7 days from today and file their report. So in turn, the Bhubaneswar Municipal Corporation to the respondent number 7, opposite party number 7 shall file a detailed affidavit with the report of the said technical team by the next date. Let the matter be listed on 1st of September 2023. A copy of this order is supplied to Mr. P.K. Mohanty and Council appearing to the Bhubaneswar Municipal Corporation. Mr. Who is appearing for this? Mr. R. B.S. Rajguru, Parent Council. When you are for the central government, Mr. Rajguru?
Yes, madam. Raiguru, madam.
Raiguru, Raiguru.
Central government, Union of India.
You provide some fund to the Bhubaneswar Municipal Corporation.
They are not the party. They are not the party.
I think they are not parties.
They are not the party.
They are not party, Mr. You are showing the Union of India, no?
But later on, we are added, my lord, by lordship's order.
Which is the order date? Can you tell us?
No, some other case, my dear.
Perhaps he is meaning some other case. In this
Then
case,
let
this
him
is
pay.
Another case was tagged with this case, my lord.
No, no.
No.
That's relating to Watco and sewage.
Mr. P.K. Mohanty, Learned Council, Learned Additional Government Advocate has appeared for the opposite parties number 1, 2, 3, and 4. And Mr. You are Mr. And Mr. P.K. Buyal and Council has appeared for the opposite party number 9 only, I think. 9 and you good name? And Mr. S.N. Das and Council has appeared for the opposite party number 4, 5, and 6.
no
5 and 6.
only 5 and 6.
5 and 6. All right. It will come on 1st of this. You also communicate to the Bhubaneswar Municipal Corporation to file an affidavit by the next day.
For the next.
1st September, it will be listed again. 31, call 30, 32.
Item number 32.
Yes, Mr. Kanungu.
Yes. This is a case, my lord. The petitioner before lordship, the subordinate judiciary peon, he was inflicted with a penalty, 5 increment, stoppage of 5 increment cumulative effect. That was by virtue of proceeding.
Who is appearing for the?
I am.
Yes.
So this is a case I have gone through
What is
that.
your stand?
Sorry.
Whether the cumulative effect would be there or not without cumulative effect made?
Yes, ma'am. That
I think we are not interfering with the penalty that we have seen. We will only do one thing. We'll modify the penalty a little bit by making it without cumulative effect. Right? We have to keep our discipline also. Mr.
2 points I want to bring your lord's attention.
Bring, yes.
Lord, the charge sheet and punishment imposed in 2003,
yes,
that has been taken cognizance while imposing this punishment, which was never formed the part of the charge sheet.
That was form of the charge.
Never form of the charge. Number one. Number two, the same disciplinary authority, he has taken cognizance of the charge sheet, 2 charge sheet initiated by himself. And out of that, 1 charge sheet, there I am exonerated, Annex A by 12. This is my case. And inquiry officer, he has imported his own knowledge and suggested punishment. These are the 2 points I have been.
No, that just try to understand that one past is a serious irregularity. I admit that the previous misconduct cannot be taken into consideration unless first there was a finding by the disciplinary authorities of misconduct has been proved. This is number one. And even if the previous disciplinary proceeding on a misconduct is taken care of by a subsequent disciplinary proceeding, that has to be reflected in the charge.
In the charge sheet.
This is a clear position of law.
That's
If
right.
you do not, you cannot take, because he has a right to say about the earlier misconduct also. Second, what is suggesting then, I do not know, because we have to enter into the findings of the inquiry authority. Usually we do not do under Article 226. Taking the personal knowledge of certain things, certain facts that was very relevant for the proceeding. But the other point Mr. Kanungu has raised, I do not find any merit in this. The disciplinary is the same disciplinary authority. If he is the disciplinary authority, it is his duty to.
My lord, the 2 proceeding again initiated after this proceeding. That is, this is 1 by 17. Second proceeding is 2 by 17. Another is 1 by 18. 1 by 18, I am exonerated by now. 2 by 18, 2 by 17 is pending. These 3 charge sheets have been initiated by the same
district. Not making any comment. Let it be come to its natural conclusion. And then, what are your difficulty with the 7 by because of the cumulative effect? 5 increments.
That is the major punishment.
Mr. Kanungu, that what kind we can make it as a minor punishment by asking withholding of the 5 increments without cumulative effect. That much we can do. If you agree now, I just 1 paragraph order I can pass. Otherwise, if you go into the records, you know there is a danger in it.
Let me pass it.
I should have passed it, Mr.
Yes, ma'am.
All right. Heard Mr. Agosti Kanungu and counsel. Appealing to the petitioner. So, by means of this petition, the petitioner has challenged the final order of punishment dated 6/2019, Annexure 7 to the petition, an order dated 16/8/2022, Annexure 9 to the petition, by which the petitioner was being dismissed. So the petitioner was proceeded by disciplinary proceeding. On the charge that the petitioner was unauthorizedly absent from the duties in the night of 9/9/2017, leaving the court and office of Nayar Chikari Gram Nyalaya, Similigoda, and proceeded to Koraput without permission of the immediate authority, and also to fail on his part to maintain, for failing on his part to maintain the absolute integrity, decorum, and conduct and devotion to duty, which misconduct is covered under Rule 3 of the Orissa Government Servants Conduct Rules 1957. There was an inquiry as the petitioner denied the charges, and after reasonable opportunity, the inquiry authority has returned the finding to the disciplinary authority, holding that the charge has been proved. The disciplinary authority, acting upon that inquiry report by the impugned order dated 6/2019, Annex 6 to the petition, has imposed the following penalty. What is that punishment of this? Your
Page 55.
55. What is the petitioner? Impose the penalty on the petitioner as noted below. Page 55(1). 5 annual increments be withheld with cumulative effect. 2. The period of suspension be treated as such. What is as such? 3. The result of the disciplinary authority be taken into account in case of any disciplinary proceeding initiated in future, as well as the proceeding pending against the delinquent at present. So the absence from the period on 9/9/2017 by the delinquent be treated as unauthorized. So the petitioner challenged the said finding and the penalty by filing an appeal. But the appellate authority has dismissed the appeal. Communicating a decision by the letter dated 16/8/2022, Annex 9 to this petition. So, Mr. M.K. Khuntial and the counsel has appeared for the opposite parties and stated that there is no infirmity in the process by which the misconduct of by which it has been held that the petitioner has committed misconduct. Having regard to the entire fact and circumstances of this case and the nature of misconduct, as proved, we are of the view that on the ground of the proportionality, the penalty that has been imposed requires some modification without remitting the matter back to the disciplinary authority. We direct certain modification in the penalty as follows. The 5 annual increments be withheld without cumulative effect. Stop. The period of suspension be treated as dies none, but without breaking service. The period of absence from the duties on 9/7/2017 has also been treated as dies none without breaking service. Stop. In terms of the above, this petition, just we are changing it. Unauthorized absence means nothing. It will be dies not, you will not get the salary of this period.
Yeah, correct.
In terms of the above, this petition is disposed of. Stop. There should be no orders to cost. A copy of this order is served, supplied to Mr. M.K. Kuntial and mentioned government advocate appearing for the opposite parties. Yes. But that we have not interfered, that it will be considered in the future, this proceeding, if he is found in the guilty. Yes.
I may be part, my lord. I may be part, my lord. Since the bench will not function after recess, my lord, my prayer is item number 34. That is the interim order is, my lord, against me. I pray, my lord, matter may be.
It will be taken up on 21st of August.
Similarly, item number 23 also may be taken up.
Item number 31, my lord. Item number 31, it was posted for.
You'll go on Tuesday next.
I will pardon my.
Next Tuesday, it will be taken up again. 31.
All the leftover matters.
Or then there is Wednesday. Wednesday 16.
All the leftover matters. All the leftover matters will come Monday.
Not on a single day, this cannot be accommodated. Postmaster will give date. Within short time, most of the matters will be accommodated.
Item number 42. I'm sorry, my lord, item number 42. It was specifically fixed to today for final disposal, my lord. Because there is an interim order which acts against me.
Already, 21st of August, it will be taken.
All right, item number 42.
33. Item 47. My minor daughter has not been recovered. Specific direction was given, my lord.
We'll just fix this matter on 16th of August again.
Yes. 45 is same, my lord. Habeas corpus.
Habeas corpus 16th of August.
My lord.
33, my lord. Item 50 to the part third matter. The
on 14th of August.
14th of August.
51.
33, my lord. Item 30.
What is the matter about?
My lord, petitioner appellant suspended since 2020. Not allowed to join, my lord.
Suspension is not revoked.
Not revoked. Last 2 years.
All right. It will be taken up on some date in 31st of August.
51, my lord. Item 51. The appeal by the state. Interim order is still to
item 51, I am appearing. Item 51, my lord, I am appearing for the respondent.
8th of September. Interim order is passed earlier. Shall continue.
Item 51, I am appearing for the respondent. Here in this case, my regularization is told over in view of these, my lords, after completing 25 years, 27 years in service, my lords.
All right, we are fixing this matter on 12th of September.
Okay.
interim order to come.
This is also there?
Same item.
All right.
Same.
51.
Yes.
That have we already fixed. 51 is fixed. What's the? Huh? 12 September. Till then, interim order will continue. All right. Call out state.
I mean, pardon, one item, small matter, 83 last item. This is a matter of 29A application matter. The 3 months I am paying for the extension.
I have no objection, my lord. I am fine. That will be allowed.
From today, my lord, 3 months.
20. What is the item number?
83, my lord. Last
83.
Here will be 39.
I have no objection, my lord. That will be allowed. I am filing the matter. I am appealing for the respondent railway matter. 83 by. I am appealing for the railway. Yes, sir.
You want the 3 months extra time?
From today, my lord.
All right. All right. You are Mr. Dotto.
No, I am Alok
You are appearing for the petitioner?
Yes, sir.
Mr. Alokranjan Mahanti, the named counsel, appears for the petitioner. And Mr. You are for the railways.
Railway. Yes, sir. Patnaik.
Yes, sir.
Patnaik.
Okay, yes, sir. Patnaik, one end. Counsel appears for the respondent. So, Mr. Patnaik at the beginning has stated that if the time is extended by 3 months from today for completion of the arbitration proceeding being ARBP number 39 of 2023, you have no objection. In this regard, he has also filed a memorandum dated 11/8/2023, which is taken on record. Stop. Take this.
Pardon, my lord, from 3 months from today.
Today, yes.
Okay.
In view of the above consensus, the time for completion of the arbitration is extended by 3 months from today. In terms of the above, this application stands allowed and disposed of. Urgent certified copy. The issue is as per rules. Yes.
Pardon me. One section 11 application was not in the list. Readings are complete.
Next week.
Old matter item number 1.
Yes.
Item 1.
Disposed of cases, decision has been filed. Are you appearing in this matter? Item number 1.
Item number 1 is a disposed of case. There is a routine, the disposed of one. The fiction has been filed. Don't have the
It is a disposed of case, just check up the record whether it is a disposed of case.
Now, here has been filed 138 of 2000.
Ah, that is there, yes. Now, how in a disposed of case such application can be entertained?
I have not filed.
Who has filed it?
I don't know. Yoshna Rani, that's fine.
I number 138 of 2023. None appears when the matter is called out. This application is not mentionable. For the purpose, it has been filed. Accordingly, it stands dismissed. Power for non-prosecution. And accordingly, it is dismissed. Next.
Item number 2. Item 2.
Wait, please, your lordship, Lord. I'm on VC if your lordship kindly permits.
Yes.
Lord, here, if your lordship sees the noting, miscellaneous petitions were filed for substitution, and also notices were issued to the respondents.
Yes.
But such notices have not yet been sufficient, my lords, on all the respondents. If your lordship permits me, I can take notice by substituted service.
But there is an order that appeal has been abated. What notice you will issue now?
But notice has already been issued upon abatement.
17/12/98 order, you please say.
Yes, my lord. Yes, my lord.
17/12/1998 order.
As if for non-substitution, the appeal had abated. So I filed an application for substitution, condonation of delay, as well as for setting aside of the abatement.
Where is that application?
Well, that is miscase number 94 of 1998, your lordship.
Yes, that is why I'm referring to that. It says,
yes,
put up the matter after 2 months, liberty to mention earlier if necessary. So what happened in this case?
Notices were issued, my lord, in the
parties have filed also the objection.
Yes, my lord. But the noting says that it is not sufficient. The noting in the cause list of your lordship, it says that the notice is not sufficient, my lords.
You are appearing for the applicant?
I am for the appellant, my lord. Yes, ma'am.
And since 2/4/1999, you have not take any steps. Is it not sufficient to dismiss the matter?
My lord,
we are in 2023. Last order was passed.
Yes, ma'am.
Notice on 2/9/1999, showing some defects, but no step has been taken by you. I think you have lost all interest in the matter. We are disposing the matter.
My lord, the appeal was admitted, my lords, in the first place. Something survives, my lord. It's a suit for partition, my lords. Your lordship will kindly consider. It's a suit for partition which was allowed to a certain extent in the first appeal. And Lord, the right to sue survives in the sense that, my lord, your lordship will decide this on certain date. Because I don't have the entire record because it's a.
That is the whole problem, that you filed the application for setting aside of the 5 years of the death.
Yes, my lord.
Yes.
I agree.
And the proceeding is still stuck up at this stage.
Well, the condonation of delay application was also filed, for which your lordships were pleased to issue notice at the relevant.
Notice, all right. Notices was taken, but last order was passed in 1998. Then so far the several defects in service, it was pointed out you have not taken any steps since 1999. Well, the court should wait for this kind of a proceeding.
No, it's absolutely not, Manoj. I bow down to that.
Then
If I may pray one chance to let's reconstitute the brief in the sense.
that is the whole problem, that after 99, if go start permitting the chances to the council or the parties, there will be no end to the litigation.
That's what my humble submission is. Your Lordship will peremptorily fix this matter to a certain date within which last chance may be granted to regularize the proceeding, Manoj. Because this has been admitted, Manoj. Your Lordship will kindly consider.
I understand that admission, someone has died, appeal abated.
Absolutely, Manoj. That
it
is
is still the state of abatement.
So,
virtually in the eye of law, there is no appeal.
There is no appeal.
The question of the order of this admission doesn't have any force at all.
Absolutely, Manoj, because of the abatement order. Your Lordship will kindly consider, Manoj. I leave it to your Lordship.
Know how will improve the things. Time was also provided to you. Again, after that, you are given the liberty to mention the matter. There was no step. Anyway, we are mentioned this. Again, take up the matter on 25th of August.
My lord.
This matter on 25th August. At the request of you are Mr.
Well, I am Somya Mishra, my lord. My power
Mr. Somya Mishra. You have the power, I think.
Lord,
you have the power.
No, but I don't have the power. On behalf of Mr. S.P. Mishra, my lord.
All right, Mr. S.K. Mishra.
That's SP.
SP Mishra.
SP, my lord. SP Mishra.
Is in your counsel. Has appeared for the appellate. The appeal is abated. And abatement was recorded by the order dated 17/12/1998. And thereafter, no steps have been taken, despite the afforded opportunity. However, as a last chance, we have fixed this matter. We have given the last chance. By this order, we are providing a final opportunity to the appellant. But this will not imply that the order of abatement has been is going to be it will not imply that order of abatement will be interfered with by this court. All right. Next.
So black.
Item number 3. Item 3.
Just check the record whether any order is there in the record, but in the digital record there is no order. Give me order. Give the orders. None appears for the appellant. This is an appeal filed against the order of injunction dated 18/8/1980. None appears. The appellant on the matter is taken up. Accordingly, the appeal stands dismissed for non-prosecution. Next.
Item number 4.
Respondent who is appearing for the appellant. Any idea?
No steps have been taken to the report noting your.
Yes.
Your Lordship, I'm appearing for respondent number 19 to 21. They were at that time minor, but they are now major, so I do not have any right, so my name.
All right, so of course we are looking into this. This is note dated 29/8/2006. It appears the steps for substitution and setting aside the abatement has not been taken despite providing several opportunities. Even today, when the matter is taken up, none appears for the appellant. Therefore, this appeal stands dismissed for non-prosecution. Your good name, sir?
Abhijit Pal.
Mr. Abhijit Pal and counsel appears for the respondent's number?
There are various respondents.
All the respondents? No.
No, my lord.
Someone has expired already.
8, 9, 10 and 11.
8, 9, 10 and 11. Are you appearing for anyone?
19 to 21. I'm appearing on behalf of Mr. A. Rautray.
Mr. Your name is?
Madhusnata Rautray.
Sir, has appeared in instruction of Mr. A. Rautray and counsel for
Respondent number 19 to 21.
19 to 22. 21. Yes. Such is stated just all right. Yes, sir. Next.
Item number 5.
And for the appellant. And for the appellant, well, is substitution notice issued against PLR proposed legal arrangement of respondent 1A by the state post was returned with a report that she is expired. I will take steps for substitution.
That this order, what will happen to this order? 17/4/1990, issue notice the PLS and the respondent, numbers 10 and 25 by registered post with AD. Recusal shall be filed within a week, failing which the appeal shall stand dismissed without further reference to the bench.
I have already taken steps, my lord.
When? Within a week or not, that has to be considered by the court only. Otherwise, the court cannot review that order.
I have taken steps. Your lordship will find from the subsequent noting in the appeal.
When have you taken steps? There is a simple question in date. Give the date. After 17/4/1999, what steps you have taken?
In respect of 1B, my lord. Respondent number 1B. This case number 129 of 2015 is filed for substitution of respondent number 1.
No,
And
we are
notice-
not on that order. We are on the order dated 17th of April 2019, which says that the notice to the PLS of the respondents number 10 and 25A by registered post with AD shall be filed within a week, failing which the appeal is automatically dismissed. The order of dismissal has been passed through the peremptory order. You show us that you took the stage before that within a week from 17/4/2029 on the PLS of the respondents number 10 and 25A.
10 and 25, my lord, the receipt is at present not with me. I have already taken steps, so your lordship may keep it.
Within 7 days from the passing of the order, had you taken step?
This is a transfer with my lord. I have appeared in their.
All right, according to the.
So I pray your lordship, a week time be given, so I will verify everything.
No, there is no question of verify. This note is very clear.
I pray 1 week time at least be given, so I will verify. This is a transfer. I have appeared in the year 20.
You are appearing for the appellant.
Appellant. I have appeared on 18/2/20. Since the previous council has died, so I appeared for the appellant.
It is yours. Huh? In that page, is anyone appearing for the appellant or respondent?
And for state is appearing for 29, respondent 29.
This has to give a note clearly mentioning whether the steps in respect of PLS of respondents number 10 and 25A was taken within 7 days from 17/4/2019 as passed in this case number 91 of 2019. Mr. S.K. Patnaik, and counsel appears with the appellant.
I may pardon my lord. A memo has been filed to that effect on 10/5/2019.
What I'm asking for 10/5 memo has been filed on 10/5.
Yes,
because you are supposed to take within 7 days the steps, whatever.
Yes.
Because already preemptory order, the court cannot review that preemptory order. It is only the consequential order will be passed, and we are passing it, fixing it on next Friday on 25/8. Yes, on 25/8. And your name, sir?
B. Panigrahi.
Mr. B. Pani, 29.
Yes, sir.
When counsel appears for the respondent number 29 and you are not on record? I'm not. Mr. S.S. Bhuyal and if counsel, you are appearing for B. Bhuyal. When counsel appears an instruction of B. Bhuyal for the respondent number? The respondent number you have. All right, just so this is real and counsel appears an instruction. For can you say the respondent's number? Not. All right, don't fix his name. You are only to, Mr. Show us that within 7 days you took steps. Otherwise, we cannot do anything. Next.
Item number 6.
Item number 6.
Item 6.
It appears from the memo dated 28/6/2019 that the sole appellant died in the year 1993. But no steps have been taken for substitution if the causes survived. Accordingly, this appeal stands dismissed as awaited for death of the sole appellant. Please, next.
Item number 7.
May I please your lordships? But the sole appellant has died. I have filed IA number 142 of 2019. That is within time at flag A. My lord may see. 142 of 2019. At flag A.
Yes.
Appellant has died. I have appeared for the legal heirs. So that is to be allowed. 142, he has died on 15/6/2019. I filed in 23/7 within the time. That has to be allowed.
22/7/2019 you filed.
Yes, ma'am.
All right.
Within 90 days. My lord.
Whether appeal was admitted?
Yes, ma'am.
By which order?
That I have not verified, ma'am. Whole brief. Appeal of 82. Appeal of 82, I don't have that, your lordship. Appeal of 82, I don't have that record.
Appeal has not been admitted.
When?
At least there is no such order.
I mean, 82, no such order. I'll verify.
24, again, it will come on 25th of August. I think appeal has not been admitted.
I'll verify, my lord. Must have 82 matter must not have been.
Because in second appeal, the appeal is admitted, there will be at least substantial question of law.
Yes, ma'am.
Though it is an old appeal, but the same principle will follow. 25th of August, taken matter will be taken up. 25th of August.
My obliged.
List on 25th of August, 2023. For the request of request to Mr. F.K. Mestro and counsel obtained to the appellant and Mr.
K.M. Dhawal. K.M. Dhawal.
K.M. Dhawal and counsel obtained to the respondent. Come prepared.
My lord.
If there is no admission, I will just ask on substantial question of law. Otherwise,
My lord, my lord.
I will not admit this appeal.
My
Yes.
Item number 8.
You are appearing for?
I am appearing for the appellant. I'll take steps. That is now 1E and 1F and 1G against. That is, they have sent it, but perhaps the returns were not there. They have sent it, the court has sent it.
Notice has already been issued, my lord. But the serving proof is not. Service proof has not come.
On 23 November 2015, you were asked to take fresh steps, but you have not taken any step. Appellant, 23rd of November 2015.
No, steps were taken.
At least this is the note of the registry. So we are dismissing it.
No, steps were taken. Notice has been sent and one AB.
You have taken steps. There was certain notices returned unserved. You are asked to take fresh steps.
Unserved, not Milord. 1A to H, they have been served. But Milord,
Current Council, just wait. Listen what I am saying. Fresh steps may be taken for issuance of the notice to respondent number 1E, not A, 1F and 1G. And that order was passed on 23rd of November 2015. And you did not take any steps. And we are almost going to complete the 8 years from that date. How would you explain your conduct?
that is not intimate, Milord. That they have been returned back. That is not intimated to.
You are supposed to know. The court will not always intimate you. The process is the part of the person who is putting the action.
We have.
You go and inspect the record. That right is with you.
Yes, Milord. File is with me. As a last chance, Milord, your lordship.
25th of August, it will be listed again. You are Mr. Acharya.
Yes.
Mr. Arun Acharya from the appellant. And you are Mr.
SD Rai. My name is also there. SD Rai.
Mr. SD Rai. You are for the respondent?
No.
I'm for with you. Mr. Arun Acharya and Mr. SD Rai and counsel appear for the appellant. None appears for the respondent and the matter is taken up. 25th of August.
I'll take steps within.
I will not observe anything.
No,
we are simply adjourning the matter. Yes.
Item 9.
Anyone is appearing for the appellant? You are appearing?
I am appearing for the respondent.
The appellant's counsel died in the year 2004.
They had taken time to substitute all of it. I think they have not been 20 years of practice.
The counsel of the appellant was reported to have passed away, and that information has been recorded by this court 5/2004. So, but thereafter, there is no representation from the appellant. So, even today, when the matter is taken up, neither the appellant nor his counsel has appeared. So, as such, this appeal stands dismissed for non-prosecution. Your good name, sir?
Ramakant.
The senior counsel has appeared for the respondent. You are appearing for all the respondents? Respondents.
Item number 10. Item 10.
You are appearing for the item number 10?
I'm on behalf of Mr. D.K. Mishra, counsel for the appellant. Lord, there is a noting that the sole respondent has died. I may humbly pray some time for taking steps. to
Respondent died when? Do you have any idea?
No, my lord, I do not.
You are talking about the appellant number 3 has also expired.
Lord, will take steps, my lord.
No, you are mentioning about the death of appellant number 3.
No, my lord, there is a noting in the list that the sole respondent has also passed away in the meantime.
Sole respondent?
Has passed away in the meantime, my lord.
Not in the meanwhile in 1993, not meanwhile.
I'm sorry, my lord. I'll take-
Sorry, learned counsel, appeal is abated and we cannot do anything. Now I will closing the appeal on abatement. It appears that the appellant number 3 died on 5/9/1993. Stop. There had been no substitution. Even not the PLRs of the appellant number 3 had appeared here. Stop. When the matter is taken up today, none appears for the appellant.
Lordship, appellant 1 and 2 are surviving.
Are you representing them?
I am on behalf of Mr. D.K. Mishra.
I am telling that, are you representing them today?
My lord, I don't have specific. One short
is-
date, I humbly pray one short date.
Just not done. So the appeal has, so far the appellant is concerned. Appellant number 3 is concerned. It has abated. Then the matter being listed on 25/8/2023. If on that day the appellants number 1 and 2 doesn't appear, are not represented before this court, this court will be compelled to pass appropriate order for non-prosecution. Next.
Item 11. Item number 11.
None appears for the appellant. This is an appeal of second appeal of 1983. Are you appearing?
I'm appealing for respondent.
I am talking about appellant. Whether the appeal was admitted, tell me. It was not admitted.
But in this matter, my lord, both the parties expired.
Appellant.
Both the parties expired. Substitution has been made. Now, the substituted elders, they entered into compromise. And I have filed that deed of partition in IA number 145 of 2002, which is now before your lordship. As per the partition deed, a compromise decree may be passed.
It is a registered deed. It is a registered deed.
Yes, sir, they have already been.
Just you come to the page. Do you have the brief with you? Page number 6 of your miscellaneous application 145.
But as per
No, it appears it is a affairs. It appears from the records that the parties have amicably settled the dispute regarding partition, and the deed of partition has been registered on 12 December 2018. So in view of the above development, this appeal has become infructuous, and accordingly the same is dismissed as infructuous. All right, next.
Item 12. Item number 12.
Yes, who is appearing? Check whether the other orders are there or not. Last order I am finding in 23/11 to 2011. Before that, any order is passed? There is nothing. First order of admission. They have not done it. Only one order is one bookmark. Tell them bookmark the orders. Just to check the physical report. I'm not getting any order. Admission, whether admission is there, huh? Because I find the substantial question of law, the paper was filed read. This 2006 judgment was reserved. No judgment was passed. On 2/3/2010, this appeal was heard and judgment was reserved. But on 29/9/2011, it was but by the order dated 29/9/2011, it was posted on 9/11/2021 for final disposal on marriage. So, thereafter, on 23/11/2021, the matter was again listed when additional evidence was allowed to be introduced. So, it was reported that it is gathered from the order dated 23/11. In the note of the registry dated 23/11 to 2011, that the appellant number 1A has passed away. No steps for substitution thereafter taken. Today, when the matter was taken up, none appeared to the appellant or the others, and as such, this appeal stands dismissed for non-prosecution.
Item 13.
Item 13, I'm in VC, my lord. And this is an appeal of 1986. and the matter has come up after almost 15-20 years, I believe. So I just spoke to the clients, my lord. So I mean, I was just informed that many of these appellants have died in between, my lord. So they have to be substituted. If some time is given, I'll try to get these things
When you
lined up,
reported
my
the
lord.
death, Learned Council, it is the duty of the council to report death.
No,
Have
no,
you
actually,
reported the death?
no, actually, I mean, I just spoke to them in the today morning after the matter was listed. So they could not give me the because they just told me appellant number 1, 2, 3, 5, 7, 11, 13 and 15 have died in between, my lord. But they could not give me the exact date. So I have to collect. I have asked them to come and meet me because they are based in Rourkela.
You are appearing for the appellant or the respondent?
No, for the appellants, my lord, for the appellants.
You are supposed to report the death. Yes, you matter will be listed again. List the matter again on 25th of August 2020.
Yes, ma'am.
It is made absolutely clear that Mr. G. Acharya and council shall file the list of the appellants with their date of who have passed away with their date of death. So it is made absolutely clear. If with the appropriate steps are not taken by the next state, this could will be compelled to pass an order for non-prosecution. Yes.
Item 14.
Obliged.
15 lot materials. The first noting is respondent number 3A, substitution not taken, abatement of appeal against respondent 3A. But all the legal errors are there on record.
Yes.
So it will not abate, its name is to be deleted.
All right.
Then secondly,
you are appearing for the appellant?
I'm appearing for appellant.
All right.
Then secondly, this case 138, 39, 37, this is for substitution of 1B. Appellant number 1B. I filed 3 applications.
You filed the application?
3 applications.
Oh, have you filed it?
Yes. These are the numbers 138, 139, and 137. Here, the substitution has to be, order has to be passed on that.
These are already in time?
No, there was delay in filing, so I filed application for condemnation of delay. And
where is those application or is it combined petition?
138, 139, and 137 in this case.
These are the substitution petition.
No, 138 is substitution petition, 139 is the condemnation of delay, and 137 for setting aside abatement. No objection has been filed. If you also condemn the delay and
no notice has been issued, how can the objection can be filed?
Notice has been, another notice be issued.
First, come to the 566, miss case number 566.
586.
566. This is the for the appellant number 1 who expired on 15/6/1996.
Yes, ma'am.
All right.
That noting is not there.
I am from the records I am telling you.
Yes,
right. Appellant number 1 has expired during pendency.
Yes. Substitution.
So, and you have filed the substitution petition, which is 566.
Yes.
It was filed in 2000, and the death took place on 15/6/1996.
Yes.
What is your petition for the condemnation? Well, give me the number. I don't like to see.
Since this application was not noted in the list, so
but it must be.
No, you'll not see me kindly see this is not in the list.
So this is the respondents I am talking about. Or that has been already been passed. Just you said the who's no, this has been substituted.
Yes.
This records is
But
not
only we followed the list.
No, just see now you are for the respondent number 3.
No, I'm for the appellant.
No, you are substitution of the respondent number 3.
First is respondent number 3A. 3 had been substituted.
3 has been substituted.
3A has to be deleted because all the years are on record.
He's already there.
All the years are on record.
All right. It has been stated by Mr. The case number. This is the item number. You are Mr. S.K. De.
Yes.
Then counsel appearing for the appellant. The legal years of the legal representative of the respondent number 3A are already on record. There is no requirement of substitution. Okay. Then you are appearing for whom?
No, my lord, this case 138, 139, 137. This is notices to go, my lord.
36,
38, 39, 37.
$38.
Yes,
this is 36 also there.
36 are not noted, my lord, in the list.
Can you repeat the case number of the substitution petitions?
Lord, sir.
I think better you inspect the records.
Yes.
Fixing the matter on 25th of August.
Yes. I'll check out that.
Just go ahead. List the matter on 25th of August of the request of Mr. S.K. Dale and counsel looking to the appellant. Mr. Dale shall make a chart of the miscellaneous application and the petition for condemnation of delay against the appropriate and showing the application for condemnation of delay against each such petition for substitution or abatement of the or setting aside the abatement. So you make a short chart of instruction, which is
Lord, may I pray item 44 is the similar matter. I'll also check out. Yeah, let's call it on
44, all the 44 also on the same date.
Same.
Is
Item 16. Sorry. Item number 15. Item number 15.
I beg pardon to answer, my lord.
you are in item number 14.
15.
15.
Okay, 15.
In between, when a senior peaker has been expired, I'll take instruction regarding the correct address. My lord, kindly allow some time.
25th of August.
25th.
Obliged on 25th of August. You are on record.
My lord.
You are on record.
I am not in record for that reason, but file is holding. I am his son.
All right. At the request of Mr. Your good name, sir?
GD Kaur.
GD Kaur, who has appeared on instruction. Stop. Guru Datta Kaur. All right. On the next date, Mr. Kaur shall apprise this court. Why the requisites for issuance of the substitution notice for the on substitution was not filed till now. Okay. That's a 86 matter or 86 matter. Requisites you have not filed so far. You just explain why you have not filed. If you have any satisfactory answer, go to the next case.
Item 16.
Yes. Who is appearing? When the matter is taken up, none appears for the appellant. The appeal is dismissed for non-exclusion. Next.
Item 17.
Same order.
Item 18.
18 Lord, I've gone through the brief, but some more requirements are there. I seek a more, only 1 week's time. Next Friday it may kindly come. I
All
will
right.
complete it.
List. You are Mr.
Mahanti, DP Mahanti.
The request of Mr. Mahanti. And counsel dealing with the appellant, let the matter be listed 25/8/2023. Stop. It appears from the list is not dated. Then in spite of reminders issued when the request let the matter be listed on such and such. All right. 25th of August.
Item 19.
But you please check the records properly.
Item number 19.
19, I am for the respondent.
Who is appealing to the appellant? Last order was passed on 18th of July 2006.
Yes, ma'am. Against a confirming judgment. Within 2007.
You are for the respondent number 1.
Yes, ma'am.
1A.
1C, 1D.
What about 1A? He has passed away. Then appears for the appellant.
We are appearing for 1C and 1D.
All right, when the matter is taken up. Despite several opportunities afforded to the appellant. Application to the substitution of the respondent number 1A, who has expired in the pendency, has not been taken. Even there is no representation today. When the matter is taken up. However, just sir, your good name?
N.K. Sahu. Mr. N.K. Sahu.
Mr. N.K. Sahu and counsel appears for the respondents number 2 and 3.
Respondent number 1C, 1D.
1C and 1D. So the appeal stands dismissed for non-prosecution. Next.
Item 20.
Appearing.
20, your lordships, with all embarrassment, this matter belongs to my grandfather. And I find all his associates' name, and we were able to retrieve the file yesterday. But no,
Fixing on 25th of August.
Lordships, yes, I'll give a letter because the appellant is must be 104 years, so obviously not
So
alive.
already you just inspect the records, what to do by.
Yes,
5th,
I'll try to send a letter and then.
But I cannot give you a long time. 25th of August will be the date.
Lordships.
Because these are the embarrassment for the court.
I absolutely.
So the matter will be listed on 25th of August if the request made by Mr. Swami Rath from counsel on instruction already.
Obliged.
Item 21. 21, my lord. I am appearing for the appellant that the petition respondent number 1 has been died on 17/12/16 and petition for substitution has been filed on 2/8/17, my lord. But 2 petition has been filed, substitution conditional delay. But some the petition for abandonment must be missing, my lord. I will check up the file, my lord. I pray 1 week time, my lord. The substitution petition, 2 petition has been filed, my lord. But abandonment petition has not been found on my lordship records, my lord. I check up, my lord. I pray some time, my lord.
You have not taken steps after the issuance of the notice.
The notice has been returned, my lord.
No, some notices are returned and served. You are asked to take the fresh notice you have not taken. I am fixing the matter on 25th August. You just inspect the records and prepare a note. Otherwise, fate is sealed of this appeal. Okay.
Item 22.
On 25th August. Here, Mr. Mahapatra.
My lord, I am there. Yes, ma'am.
Mr. D.R. Mahapatra and counsel appealing to the appellant. Mr. Mahapatra, it is an appeal of 1986. There may be a gap in the registry. Why you are not mentioning this matter? Such an old matter in the High Court pending. All right, next.
Sorry,
22.
Item 22.
Just check the record whether the certificate of copy of the judgment is there or not. Okay. Only just check the certificate copies filed on that. Fine. None appeals for the appellant. Dismiss the appeal for non-prosecution. The appeal is dismissed for non-prosecution.
Item 23.
23. In spite of repeated letter, nobody is turning up. Your
You are
lordship,
appearing
adjourn
to
this matter is the last chance, Lord.
What chance?
That's
What are you
nobody is
talking?
turning up. We are for the appellant.
May I please your lordships? I'm on BC, my lord.
Yes.
My lord, I have instruction to appear for the legal errors of respondent number 12.
Yes. Appearing for the
Respondent number 12, my lord. Legal errors of respondent number 12.
12.
12, 1, 2.
Whether the respondent number 12 has been substituted?
My lord, the substitution applications are actually pending since 1997. It has not been substituted.
The lordship. The lordship may adjourn this matter as a last chance to a particular date. I will take instruction in the meantime.
What kind
If
of
nobody
instruction?
turn up, then
The condonation application also not actually allowed.
yes, ma'am.
This is a matter of 1997.
Because
All
since
right, 25th
2086,
of August. At the request
we have
of,
issued letter repeatedly from 2002.
it is 22.
No.
23. 23. At the request of Mr. R. K. Mahapatra and council. But no further recommendation will be made in the next date. And you have filed the Vagalatnama?
No, my lord.
So all right, I am not reflecting your name. 25th matter will be again coming.
Yes.
All right.
Item 24.
Item 23. Let's in item 23, I had entered appearance for behalf of respondent number 3.
In which matter?
23, Millards.
Second appeal 254 1986.
Millards, second appeal 200, 23, just the matter which was heard. I was there for respondent number 3, but I have instructions. My name does not reflect. That's in the cause list.
Under that council has stated that he has appeared for the respondent number
3.
But by filing the power.
But in the meantime, he has already expired, Millards. That is my instruction.
The respondent 3 expired.
Yes, Millards.
Having on council on instruction has informed this court the respondent number 3 has expired. Can you tell the year?
Millards, I will have
long back.
Long back,
but no steps on behalf of the appellant was taken. So appeal is abated and dismissed.
I will take all necessary instruction if they.
All right, 25th. I have recorded this because of on 25th it will be taken again. Yes.
Well, can it be on
no further
20th?
time? This is maximum.
I will
time.
be absent on 25th.
No. You depute any other, because these are the embarrassment for the court. I
Yes,
will not keep this pending on such a way. Yes.
All right, item 24.
Grateful.
May I please, Your Lordship?
Yes.
Milords, this is a tagged up matter. Along with the second appeal, there is a WPC, Milords. In both the WPC, I am the petitioner, and this second appeal, I am the appellant, Milords. Milords, may kindly peruse the noting of the WPC. We have taken steps to substitute the opposite parties. Substitution was allowed, notices were issued, and it has been served, and the addressee refused to accept that. It was that the service is complete, Milords. In the meantime, just a month or two ago, Milords, the sole appellant has died.
Died,
Milords. Just a month or two. So we need to take steps accordingly, Milords.
list on 25/8/2023. Your record on the record.
Milords.
Are you on the?
No, I'm on behalf of Mr. S.K. Padhi, Milords.
Yes.
On behalf of Mr. S.K. Padhi.
S.K. Pani.
Milords.
Mr. Your good name?
Subham Sharma.
Mr. Shuman Sharma, the counsel.
May I submit, my lord?
Has appeared on instruction of Mr. S.K. Pani, Learned Counsel, and informed that the sole appellant has expired in the pendency. Let the matter be listed on 25th of August 2023. You are also appearing?
I am appealing for in the writ 1, 2, 3, 4. In the writ, OP number 6 also died in meantime.
All right, just a minute. Please 23.
Writ 5480 by 9.
Okay, number 6.
Number 6. Here, Mr. N.P. Purija.
OP number 9 died.
Huh?
Sorry.
Mr.
OP number 9 died.
Yes, Mr. N.P. Purija, Learned Counsel, appearing for the respondent has submitted that. Who died? Who expired?
Milords, 9 has been substituted, Milords. 9 has been already been substituted.
Only respondent number 9.
No, Milords.
No.
Only respondent number 9 passed away.
No, respondent no. Only opposite party number 9 in the writ petition. Opposite party 9 and 1.
I mean, respondent is a second appeal. You are mentioning to any matter, other matter.
Connected matter, Milord. Tagged up matter.
They are connected matter.
No, we are on the appeal. These are connected writ petition. We do not know what the bearing over the appeal those I have. Who expired according to from the appeal you say?
No, not in appeal.
No, already then Mr. N.P. Purija and counsel has appeared for the sole respondent, I think.
Milords, just to approach both the cases are connected to each other, Milords, because it arises out of a single dispute and two simultaneous proceedings were initiated. So both the matters have to be tagged up when it is here.
No, these will remain tagged up, but will not reflect anything about the writ petition.
Milords.
Yes. It will come on 25/8. If any proper step is not taken, it will be dismissed the matter. Yes.
Item number 25.
25, I'm for the petitioner, my lord. And on behalf of Mr. Deo, I beg your pardon that I'm annexing seeking a short adjournment, my lord.
What for?
On
What is the
behalf of
purpose
Mr.
will be served?
Sorry.
No, lawyer's absence doesn't matter. This is a matter
No,
relating to 1987. Sorry.
No, the fact is,
We have clearly stated that no adjournment will be entertained.
no, the fact is that Mr. Deo's wife has been admitted hospital since last 3 days.
All right, this is the matter on 25/8/2023. There is request made for Mr. This 25, no? Mr. as the A.
Mr.
Dev.
Deo.
Mr. A.
I'm for opposite party on 4 years.
All right. You are appealing for?
OP 4 years.
Mr.
B. Panigray.
B. Panigray, Learning Council appears for the copy number 4. Next 26.
Item 26.
Obliged, my lord. Obliged.
Item number 26, I have no instruction. Since
You are for?
I am for my name was appearing for the appellant. and I have got no instruction because the file,
Alright.
while I was
You are Mr. What is the good name, sir?
PC Cor.
Mr. PC call and counsel appears with the appellant and submitted that he has no instruction. So, in view of the above statement, this appeal stands dismissed for non-prosecution.
Item 27.
27, my lord, on behalf of Mr. Ek Mishra, my lord, we have no instructions, my lord. We have no instructions in the matter, my lord.
You have no
instructions, my lord.
Here for the appellant?
My lord, on behalf of Mr. Ek Mishra.
What is your good name, sir?
Anup Mishra, my lord.
Mr. Anup Mishra, learned counsel, appeal on instruction of Mr. A. Mishra or
Ek Mishra, Ek Mishra, on behalf of-
learned counsel, appealing with the appellant has stated that there is no instruction. So, the appeal therefore stands dismissed for non-prosecution. Next.
Item 28.
Item 28, my lord.
Yes.
Partly reversing and partly confirming judgment.
You come to the grounds A to D and H. Pardon? You come to the ground A to D and H under paragraph 12. This is your substantial question of law. Just tell us how it is a substantial question of law.
Pardon. My first point of argument, my lord, so far paragraph A is concerned.
Yes.
The evidence of the PW 2, 4, 5, 6 and PW 1 is categorically stated regarding that gift deed vis-a-vis the acceptance of gift deed has not been denied, but the learned court has not taken into account of that section 50 of the Evidence Act and expunged the evidence of PW 2, 3, 2, 4, 5, 6 vis-a-vis DW1. And so far exhibit 6 is concerned, that is in Nika registered of the year 1948 and held that is an
Page?
Pardon?
Ground A.
Page number.
Where from your ground starts? Where from the which page the ground starts?
Ground space 16 million.
16 onwards. Yes.
First ground below there, Marian B, the defendant of 4. Prepared is.
So your substantial question is whether the evidence of PW 2, 4, 5 and D1 satisfied the ingredient of section 50 of the
50 of the evidence.
Act. That is what the first.
Yes. And second point.
How it is a substantial question of law?
Well, that evidence is confined to about that gift deed. Gift deed. All the PWs, vis-a-vis the DWs are said about the gift deed.
I am asking about your framing of the substantial question of law. Maybe there is a substantial question of law, but the way you have framed this question, is it a substantial question of
Well,
law?
I have not verified the question has been framed by this honorable court.
No, I am, Mr. Mestro, just calm this. Whether the evidence of PW 2, 4, 5, 6 and DW 1 satisfy the ingredients of the section 50 of the Evidence Act and the principle of enunciated in such and such. Answer would be yes and no on appreciation of the fact. Right?
Yes.
How that can be a substantial question of law?
Appreciation of evidence is not a substance of law.
I understand. That then you have to say the inference drawn
Yes.
by the court below is in derogations of the evidence, which is
Of
on the
section 50 of the.
you have not framed that way.
I have not verified the.
But
the
this is
substantial
the
question has been framed by this honorable court. On the stage of admission.
Unfortunate of a counsel like you that you are making
No,
a statement.
And second
Because section 100, subsection 4 of the, it is the liability of the council.
Council to say.
Council has to frame. Yes.
To establish the.
So this is not a substantial question of law. You asked what is the reply on appreciation of the evidence. It may be yes or no.
Yes, sir.
And this is not a ground on perversity. Yes, next.
May I sort a short adjournment to verify the document substantial question?
List on 25/8/2022 at the request.
25 million.
25th August.
Obliged.
At the request of Mr. T.K. Mistral and counsel for the appellant. Stop. I find there is a serious problem with the framing of the substantial question of law. Because Judge has
my lord, I have not seen the question.
That's the difficulties. Inspect the record in the meanwhile. I am giving you the date.
Yes, in the meantime,
I am reading the substantial question of how it is in 18/8/1987. You take note. 18/8/1987, the substantial question of law was framed. And it was framed in the following manner. The substantial questions of law to be asked in this appeal are stated in grounds A to grounds D and H of paragraph 12 of the Memorandum of Appeal. This is completely contrary to the prescription of subsection 4 of 100.
Correct.
So you have to meet this legal question also.
Yes.
All right.
Item 29.
Item 29. In item 29, I am for the appellant. The appeal has abated now. Both of them have expired and no substitution has been taken.
You are Mr.
I am Mr. Balakrishna. I have no power. It is my father's.
You are appearing for your father. Good. What is your good name, sir?
P.V. Balakrishna.
Mr. P.U. Sajjan Search appears and inform this court, both the appellants.
Appellant and respondent.
Appellants have respondent 1 have expired. No substitution. Therefore, appeal has abated. When died, can you say?
About 10-15 years back now.
All right. Died 10 to 15 years back. Huh? Okay. Despite several opportunities provided to the appellant to take the steps for substitution, no such step has been taken. This appeal therefore stands dismissed as abated. Long done. Up to 30 you call and thereafter you go to the part.
Item number 30.
Item 30, for convenience, I've just prepared a very short note for your lordship. This is against the reversing judgment. The substantial questions of law, the appeal was admitted on 29/10/87 on grounds 1, 2, 3, and 5. I have tried to extract them on the next page. Now, the main point on which we have a case would be that the lower appellate court, while reversing the findings of the trial court, has actually not given due regard to all the discussions of the trial court. That judgment also I have given, my lords, where, of course, this is not a part of the questions formulated, but this may be one of the main contentions of ours.
Can you just give the reference of when the substantial question of law was formulated?
It was on 29/10/1987.
29/10.
My lords. That is what our appeal memo records.
There is a ground number 1, 2, 3, and 5.
My lords. 1, 2, 3, and 5. Those grounds I have tried to extract in the short note also.
Anybody is appearing for the respondent?
Mr. P.K. Nanda's name is there in the cause list.
But he is not here.
He is not here.
Heard in part that the matter was listed on 25th of August again. You just inform Mr. Nanda.
I'll try to
get it scanned. The other matters will be listed on 25th August again. The remaining matter, because I now call up the arbitration matters. All other matters listed and such.
We are all ready.
For hearing, yes.
Matter listed on fresh admission. Item number 75. Item 75.
None appears list on 25th of August 2023. Next.
Item 76.
Blood item 75. I'm sorry, blood. Item 75. That's dismissed for default.
We fixed it on 25th of August. Come on that day.
Item 76.
76, your lordships, this is a matter where Mr. Panigrai was appointed. And thereafter, the opposite side objected. It had not appeared in the first round. Objected that Mr. Panigrai happens to be a senior, in fact, and he happens to be a junior of my grandfather, and therefore he should be dropped. So, anyways, he's withdrawn, and so that's why
Panigrai is withdrawn.
He's withdrawn his mandate. They also went and challenged under section 14. So he's withdrawn. So we need.
Actually, we have to appoint a new arbitrator.
Yes, new.
They have very common name.
And they have, and what they did is when they up. No, your lordships. Your lordships may appoint.
Yes.
Let's not go by these suggestions. We leave it to your lordships' wisdom. But only thing we want to point out, they had made a huge delay. They did not appear. So
What is the stake? What is the amount of the claim?
It's a very small amount. And half the amount that we had deposited fees has already been dispersed.
Yes.
And some work had happened before Mr. Panigrai. So there's a small amount left. Your lordships may.
I appoint Miss Sagurika Sahu to be the arbitrator.
Oh, she can't because she's assisting me in that matter.
Okay. A list is there, okay. That's all. I am appointing Prashanta Kumar Jena because stake is very low. He's all right. Absolutely. Any problem, Mr. Prashanta Kumar Jena?
Mr. Lordship may appoint, but I am suggesting the name of Honorable Mr. Justice.
No, we are appointing, Prashant Kumar Jena. But Miss, you are appearing for these
Opposite party.
I'm for IDC. And because
DC
IDC
Jana.
had that clause of its.
who is assisting you today? JP Behra.
JP.
MS Tommy Roth from the Senate Council, listed by JP Behra, appears for the petitioner. And
My
Mr.
name may be reflected. I am appearing today.
Huh?
My name may be reflected for the opposite party.
You are Mr.
Subrat Mishra.
You filed the Vakalat number. Today you are filing.
Yes.
Mr. Subrat Mishra, learned counsel, has filed the power for appearing for the opposite party. Power is taken on record. So it has been stated by counsel that Mr. N.K. Panigrahi, what is the
NC Panigrahi.
NC Panigrahi, the arbitrator appointed by this court earlier, has relinquished the assignment as there was an application on section 14 of the Arbitration Act. So, thus, the occasion occasion arose for the appointment of, has arisen for appointment of a fresh arbitrator. Considering the stake and the nature of the controversy, the nature of the dispute, this could appoint Mr. Prashant Kumar Jena, advocate, as the arbitrator. So, date of appearance, if given, it will be, I think, helpful. But if direct the coordination arbitration to fix the date and comment.
The center fixes the.
All right. The coordinator, High Court Arbitration Center, shall fix the date of appearance of the parties on consultation with the arbitrator. According to this petition stands disposed of. Next.
Item 77.
77 for the expression of the ARB.
But I was not the conducting counsel because this is a transfer bid, my lord. My lord, it was dismissed on 23/4/2021. And due to COVID and his asthmatic patient, my lord, could not know about the dismissal. And this application filed on 23/12/22.
No, just you know whether the notice has been received by the other side.
Well, CMPL, my lord, I had taken notice. The ADA of admission notice of number 2 and not yet back. But
So-
tracking report says that delivery of notice to the opposite party. my lord.
All right, we just fix another date, 25th of August. Let them see whether it appears from the registry's note dated such and such date 19/6/2023 that the registered notice has been delivered on the opposite party, but there is no representation today. For giving another chance of representation, let the matter be listed on 25/8/2023. Mr. D.K. Saul and counsel appears for the petitioner. All right.
Posted to my lord. I take it.
25th of August.
Item 78.
My lordship, on behalf of Mr. SUBHASIS, he's not well. Kindly give some adjournment.
It's a criminal matter. It's a criminal matter. Huh? Why it has been listed today? 482 petition.
Lordship,
When do we want it?
any day, any other day. He is not,
25th of August.
okay, my lord. Obliged.
You are appearing for whom?
Sambit Samal, Mr. Sambit Samal, petitioner, bank,
PK?
Mr. Sambit Samal,
Your name?
Somya Mishra.
Ms. Shama Mr. Learned Counsel appearing on behalf of Mr. Sachin Such has requested for a short accommodation that the matter be listed on Secretary 20 people. Right.
Please, my lord.
Item 79.
I am for the petitioner, my lord.
Yes.
Your Lordships, we have not filed counter, but have gone through it. Appointment inevitably happened, but we have an objection on this point that they want some judge from Delhi, which will be very inconvenient for us. So your Lordships may appoint somebody from here. Here, your Lordships.
Mr. Mahanti is online.
But your lordship may appoint anyone from the board.
And I think this is reasonably a high amount, so we'll have a
Senior
judge.
All right. Justice Mahapatra is taking up the matter.
That would be
Mahapatra.
Somebody else. I think these too much appointments they have there.
Okay.
Justice Patnaik, Pramod Patnaik. I don't know if Mr. Mahanti will agree.
Pramod Patnaik. He is more than 17 reference already is there. What about Justice Vishwajit Mahanti? I think he can be.
Vishwajit, Mr.
Justice Vishwajit Mahanti.
Lordship, no problem.
Lordship.
Yes. But you are for the petitioner?
Lordship, they are for the petition. Mr. Mahanti is for petition. I am for Nalco, opposite party.
Mr. S. Mahanti, Learned Counsel appears for the petitioner and Ms. Swami Roth, the senior counsel, listed by
Sucheta Gumansi.
Kumar appears for the opposite party. In terms of the arbitration clause and having due regard to the nature of the dispute, Justice Vishwajit Mahanti, a retired judge of the High Court of Orissa, is appointed as the sole arbitrator. Stop. The coordinator, High Court Arbitration Center, shall appoint a date after consulting the appointed arbitrator and issue the notice to the parties for appearance accordingly. The petition stands disposed of.
Item 80.
Grateful, Your Lordship.
80, I just want to inform your Lordships, here also we are appearing for opposite party 2 and 3. Meanwhile, this opposite party 2 and 3 have been merged with OMC. So probably they'll have to substitute and then
Just take the information, list the matter on 25th August. In the meanwhile, necessary application for substitution in view of the taking over of the management be made by the petitioner.
Obliged.
All right. Mr. K.K. Raut, Learned Counsel, has appeared for the petitioner. Ms. Swami Roth, Learned Counsel, has appeared for the, listed by Ms. P. Mohanty.
Mr. P. Mahanti. This is then another court.
All right. 25th August, it will come file an application. All right. Other matters will go to 25th. Because I have
Item 75.
Huh?
Item 75.
We have passed it on 25th August, it will go again. You are not there. All right. The other matter just fixed. Two more matters. 82 remained. All right. Call.
Item 81.
81, I pray some more time to file counter.
In 81?
Yes, my lord.
Last time, my lord.
Mr. P.K. Moduli, but it will come on 25th of August.
Some more time, 1 week more.
As per the, my lord,
29th, sorry, 25th, and then it's coming on the first of September. First. At the request of Mr. P.K. Moduli and counsel appearing for the opposite party, let the matter be listed on 1st of September 2023. Anyone is appearing for the petitioner in the matter?
my lord, I am for the petitioner, my lord. The matter had come up before the bench of your lordship on 2nd day, 19th May 2023, order number 2. Last opportunity was given to the Lord and Counsel for the opposite party.
All right.
For last chance.
All right, on the last day, next day you raise this objection, will impose a cost on them. Yes.
Item 82.
My learned senior was also in this side. My learned senior was also this side. He is
This
no.
opportunity also the APCO senior. That he doesn't raise that issue again. Yes.
82.
There's for the petitioner, notices were issued and subsequently they have appeared. We're supposed to file counter.
Rejoinder.
82, I am appearing for the opposite party number 1 and 2. Kindly pray for 2 weeks time to file the counter.
All right, then, you are there, Shudipto, on record. Let the matter be listed 1st of September 2023. At the request of, what is your good name? Your good name.
SK Swine.
You are not on record?
Record.
You record. Mr. SK Swine and counsel appearing for the opposite party. In the meanwhile, the opposite party shall invariably file their objection, if any. No further accommodation will be made for the same purpose. Mr. Shudipto Pandal and counsel was approved for the petition.
Much obliged.
Grateful.
For orders, item number 1, CMAPL 113 of 2023.
I have filed CMPL 113 2023.
Yes.
Arising out of WPC number 21376 by 14,
Yes.
which has been dismissed during the year 21.
We'll be restoring your petition on condition that the matter will be heard on merit on 1st of September.
I was remained absent due to my health ground. This is my treatment file.
No,
And
that
that-
is why we are fixing the final hearing. We are restoring your case by setting aside the order of dismissal, but you are to be there on 1st of September for final hearing. We are understandable to you?
Right. Again?
September 1 तारिख दिन फाइनल हियरिंग ପାଇଁ रेडी अछंती आपण
हाँ.
All right. I number 159 of 2023.
आज भी ready अच्छी तो जमा
This is the application filed for setting aside the order dated 17/2021. Passed in WPC number 21376 of 2014. Is the line in the paper? It will separate the file. Just what read again. So recalling the order dated second six by which the writ petition number second six was dismissed for non-prosecution. We have heard the applicant in person. Stop. Even though there is no reason has been assigned, that in view of the fact that the petitioner was on that day, was hospitalized, and for that reason he could not come, we recall the said order, that is 17/2021, by restoring the above mentioned writ petition to its original file. In terms thereof, this petition is disposed of in the main. It appears from the records that essay has not been done. So, is it writ petition? What is for the first line, the requirement of the certified copy of the order, which has been sought to be recalled, is dispensed with. As a downloaded copy of the said order has been filed. Is order passed. Let the matter be listed on 1/9/2023 for hearing on merit. Come on that date, 1/9/2023, September.
September 1 तारिख दिन आसबे फाइनल हियरिंग हबो
For hearing on merit. All right.
I may be pardoned, my lord.
Yes.
These two memos for modification earlier disposed by Honorable Mr. Justice, Honorable then Chief Justice.
What is this?
This is more for modification, my lord.
All right. Let us see what is the application you have filed.
Income tax matters.
That should be listed before the registered judicial. Place these memos for the registered judicial because bench will be required to be constituted. In the judicial side, I cannot constitute any bench. So go to the registered judicial, instruction is there. He will accept it and he will place it before on the administrative side.
I may be
Yes.
pardoned, Your Lordship, to make a mention, Your Lordship. A restoration arising out of writ appeal, Your Lordship, dismissed for default within time period. Lordship.
Dismissed for default within time.
Writ appeal was dismissed for default, and we have filed the restoration within the time period 30 days.
All right, take the motion.
Same may be kindly listed on 18.
No, whether the same bench should be constituted there, no?
Now, this is the bench or any other
Same
bench?
bench, Your Lordship.
I was party to that.
Yes,
Ask them to bring to the registered judiciary.
Oblige, Your Lordship.
For orders item number 1.
Sir,
Item
here, my lord,
number-
I am appearing for the respondent
Item 1, Your Lordship.
application for modification of
I-
the order.
I pray for one time, Your Lordship, 7 days.
But
time, Your
whether it is maintainable,
My lord,
writ appeal is maintainable.
yes,
Writ appeal is maintainable. You have withdrawn from Supreme Court
my lord,
against a single bench judgment.
yes, Your Lordship.
Is it maintainable here against the order passed under Article 227?
Yes, the writ appeal already,
No, question is that whether an appeal, writ appeal is maintainable against an order passed under Article
my
227.
lordship, in this
The
matter.
full bench of this
Yes.
honorable
Not on the
court
full bench, it is the Supreme
confirmed by
Court
Supreme
decision.
Court. Right?
Yes.
Full bench decision has been confirmed by Supreme Court.
So, Lordship,
So after that,
arguing I pray, Lordship, in this case, the arguing counsel is Mr. Joyce from Delhi, Lordship, Supreme Court. He is on personal accommodation for which 7 days time, Lordship, and appeal appraisal, Lordship, on that day, Lordship. 7 days after any day, Lordship, may please.
Based on 25th of August.
Ma'am.
Is the last opportunity. On that day, the learned counsel will be appealing to the appellant shall satisfy this court, then appeal from an order passed under intercourt appeal is maintainable from an order passed under Article 226(7) of the Constitution of India.
My lord, there is an interim
Oh,
order.
Interim order is there.
Interim order in my favor because the appeal was disposed of.
How the interim order is there?
My lord, your lordship will carry this. By
The writ appeal was allowed, Your Lordship.
The fact, my lord. The appeal was disposed of ex parte.
So what?
Ex parte, my lord, this London single judge has quashed the proceeding before the sub-collector.
Yes.
Here they have said that the matter was.
No, because there is
Because,
no.
my lord,
This is the writ appeal has not been admitted.
Yes, Your Lordship, disposed of.
Then?
Writ appeal allowed, Your Lordship.
Disposed of. They have my lord, the London.
Writ appeal has been disposed of.
Yes.
Writ appeal allowed, Your Lordship. Thereafter,
Okay.
my Lord Senior
My-
filed an application for modification of that order, which has been notice was issued that modification, IA, Your Lordship.
My lord, here
And the
the
interim order has been passed, Your
The
Lordship.
London single judge has quashed the mutation proceeding, my lord, by misrepresenting the fact that it was remanded for which the appeal was disposed of, directing the sub-collector to dispose of the appeal, which is not there by the order of the London single judge, my lord. When I have received the notice that
All right, interim order passed on 21/4/2022 shall continue till the next date.
Oblige.
Interim order already passed. It has been also entertained. That is why we have framed the question of entertainment. Yes. No, there is a, just you bring the judgment of the Supreme Court of 1977, that the intra-court appeal or the letter patent appeal from an order passed under Article 227 is not.
yes, my lord, there are many decisions, my lord.
And just brother is saying there is a full court decision, full bench decision of this.
Yes, yes.
Right.
Your lordship is
2008,
Yeah.
our full bench decision that
Supreme
is confirmed in 2010.
All right.
Item number 2.
Your lordship is calling it 25th August.
25th August.
Lordship, may I appeal, Lordship? Modification order, Lordship, on that day wrongly mentioned that the representation pending before OP number 3, but it was pending OP number 2, Lordship. That is to modify, Lordship.
Where is this? This collector OP number 2.
Lordship, long day mentioned, but it was pending OP number 2, Lordship, RDC.
All right, just a minute, let us check.
In the writ petition, collector is OP number 3.
So this is the mistake.
Mistake,
This is the only mistake.
Only mistake.
All
So who is to consider? Who is to
Collector-
consider?
Collector will
Lordship,
consider.
2.
RDC.
RDC, Lordship.
RDC is required to consider.
Lordship.
Okay.
RDC is the committee chairperson.
Lordship,
RDC is
chairperson of-
empowered.
Lordship, empowered to the consider.
There's
Yes.
no scrutiny committee. This
But here, they are not party. State level scrutiny committee is not a party here. He has given representation to the collector as well as RDC.
RDC, Lordship.
He wants RDC to be directed for consideration.
Lordship.
so you
that is
want
only-
modification of that order.
Lordship, only instead of
All right.
3-2.
It has been stated by Mr. UC Doral and counsel appearing for the writ petitioner that inadvertently in the order dated 16/2/2023, it has been recorded that the representation filed by the petitioner shall be examined by the collector Bhadrag, opposite party number 3.
RDC considers, you will lose the.
No, just wait. After notice to the petitioner as well as opposite party number 5, and after giving them an opportunity of hearing, a reasonable order shall be passed thereon by the collector Bhadrag on later, not later than, it is the 1st of May or what?
What's it?
What is the line? The 1st of May?
That
The
was the order, first of.
1st of May. 1st of May 2023. All right. According to Mr. Doral and its counsel, the collector Bhadrag, within bracket the opposite party number 3, cannot consider this such representation. Because in terms of the Supreme Court decision in this is a subsequent decision. Madhuri Patil.
AA 1995 Supreme.
No, Madhuri Patil is 94. There's a 95 decision.
SCC reported is 94, AA is 1990.
Madhuri Patil again, 3 judges bench considered.
No, this is all right, but these are 96, 5 there is another decision, that is more elaborate decision, that I will find out. This, 1996, 5 Supreme Court. So only the state levels, we call it state level scrutiny committee, can entertain such representation for relook at the status. So, according to Mr. Dora, this is a commissioner revenue department, or what is the name is known as divisional commissioner.
Yes. Divisional commissioner,
Central Division Court of is the authority through whom the representation is placed before the state level scrutiny committee. Be that as it may, we are of the view that if we modify the order, that will not change the basic purpose of the said order. Accordingly, in the place where quote unquote the collector Bhadrag within bracket opposite party number 3 are appearing, that will be, or the collector Bhadrag are appearing, collector Bhadrag within court, that shall be substituted by the Revenue Divisional Commissioner Cutter, Central Division Cutter, within bracket, the opposite party number 2, or the Divisional Commissioner, Central Division Cutter, quote unquote. Stop. So the order shall be corrected accordingly. In terms of above, this application stands disposed of. For the next matter.
For orders item number 1.
The petitioner filed for the restoration of a WA number 888 of 2022, which was dismissed for default on 4/4/2023. You are not there on that day? No, madam. I'm on behalf of the Kalpana Naik. You are appearing for someone else? No. All right. What is the reason you have shown? Within the day, the staircase was conducted by the one advocate. The day the case was listed, he was not present. For which the due to for non-communication between the petitioner and the case of this. This is an application filed by the why this earlier application was filed? Which has been dismissed for non-prosecution. Only WA number 4888 of 2022 million. That was the default on 4/4/2023 million. That is what. Notice was issued whether someone has come or not. No notice was issued. Notice is not issued. Your good name, sir? Osmiya Ranjan Majhi. Third sentence, there is an application seeking the condemnation of delay in filing the petition for restoration. Will be opposing, Mr.
No, madam.
Huh?
No, madam.
Since Mr. M.K. Kunjiyal, an additional government advocate appearing for the opposite parties, has stated that the delay of 61 days will not be opposed by the or will not be opposed. Having regard to the explanation given, though inadequate, we are of the view that for substantive rights of justice, the said delay should be condoned, and accordingly it is ordered, and the result of this petition is disposed of. Now come to the main petition. Hello? Come to the main petition. 888 of 888 of 2022. 888 of 22.
What is the impugned order?
There is no impugned order.
What is that?
No impugned order. Huh? The said W was filed the challenging the order of single judge in where the single judge has rejected the prayer of the petitioner.
Case 10 is the impugned. Who's there? Case 7. This is an application. Heard Mr. Sachin sir. This is an application. Also Mr. Name, Mr. Jail. This is an application seeking recalling the order dated. So this is an application by the writ appellant, by the appellant in WA number just 888 of 2022 for recalling the order dated 4/4/2023 by which the said writ appeal was dismissed for non-prosecution. It has been stated that the counsel who was supervising the case has not informed the counsel, namely Miss Kalpana Naik. Miss Kalpana Naik. As a result, she did not appear when the matter was taken up. Having regard to the substantive ends of justice, we recall the order dated 4/4/2023 and set aside the same. So, as consequence, the WA number such and such is restored to its original file. And the result, this application is allowed and disposed of. In WA file, there is not with the record today. It is there. The matter will be taken up for hearing on the 1st of September. And on that day, if there is no representation, please the WA. This appeal for hearing on merit on 1st of September 2023. It is made absolutely clear, no accommodation will be made on that day.
There is one for the amendment of the plain Miller. In WA, there is one miscase was pending for the amendment of the plain Miller.
What is the amendment do you want?
I mean, there is subsequently some changes have been made.
Where is that petition? Where will this come?
In the original W.
Mr. Madhuri, do you have any objection? This is taking new grounds.
That amendment, copy not solved.
Serve the copy first.
Restoration petition CMPL not solved. But ठीक है, objection.
2023.
But you cannot make these pairs in the WA. So the third entry will not entertain.
Miller.
Third entry you cannot bring a new relief in the writ appeal. Others we are entertaining as a ground. All right. Thus we entertain this petition. But the relief that has been sought, that we are not entertaining. How a writ appeal you can bring a fresh relief? How can you do that?
Initially, the writ petition was dismissed on the ground of
No, my question is how can you incorporate a new relief in the memorandum of appeal?
There is no new relief, Miller.
That just come.
Only there is some changes.
Just come and direct the respondent to consider the candidature of the appellant at par with the such and such, such and such, such and such, this relief was not in the writ petition.
Milord, permitted to withdraw the same amendment petition only.
All right, that is much better.
Milord.
Mr. Sajjan sir, as at the outset submitted that he will not praise the amendment petition. According to the amendment petition, stands dismissed as not placed. This is just a score out. Sajjan sir, there is an application seeking amendment of the memorandum of appeal, being WA number 888 of 2022. At the outset, Mr. Sajjan sir, appearing for the applicant has stated that he will not place this amendment, proposed amendment, and according to the same stance dismissed as not placed. So,
Obliging.